Original function is the urgent matter for review petition. And last time on third, I mentioned this matter, and as per your direction, we have served the copy to the all the
Review of
regarding review petition, your order dated.
writ petition.
Review petition, my lord.
Writ petition.
Yes, my lord. I mentioned in the chamber that you directed me to serve the copy to the all opposite party. We already served the copy, and that is a video of service. My lord, kindly date the fix the date.
You have served the copy?
Yes, already served. I already the affidavit of position, already supplement affidavit of service also.
Okay, listed here the review.
Grateful, my lord.
Item number 5, For the petitioner, my lord, for personal inconvenience, I am praying, my lord, to fix this matter after 2 weeks.
After 2 weeks, why?
My lord, my maternal grandmother has passed away. I have
Okay.
We are for the state, my lord.
On the request of the learned counsel for the petitioner due to bereavement,
My lord.
yes, next.
My lord, I'm appearing for the
Who is appearing for the petitioner?
লাস্ট অর্ডারটাই দেখো তো কার নাম আছে most probably Mr. Majumdar was appearing.
The last occasion also non-represented
Not
the petitioner.
represented.
This is part heard matter already.
Well, it's the case of 498A.
Do you have CD?
My lord, I've got the case type.
Probably going to have instruction. Mr. Majumdar is probably not appearing in this matter.
Will not appear.
Probably not appearing.
I am closing this case.
Your lordship, I just received.
I have already heard this matter.
Many attempts on my lord.
There's probably a change. I'll just indicate.
Maybe whatever, maybe.
Or
If
Mr. Majumdar's
nobody is appear on behalf of the petitioner, how many times court will allow the
I have no.
adjournment?
I just heard, my lord, that Mr. Majumdar.
Whatever may be.
And my lord, the difficulty that we are facing is because there was an order of no coercive state,
Yes,
we cannot
yes, yes.
file any charge sheet also. This is the difficulty.
You file your charge sheet.
My lord, should I please the case or my lord would?
The case diary, please give
Yes,
me the
I'm
case
giving.
diary. What is
Yes,
the materials against the
Yes, my lord. হ্যাঁ এটাই দিচ্ছি
petitioner? 498A.
Yes, my lord. My lord, I'm giving your lordship the statement of the neighbors who have supported the prosecution case. না না এখানে রেখে দিয়ে যায় পড়তে এখন অনেক দেরি আছে ভাই না হারিয়ে যায় আমার তুই রাখ বা তার আগে দেবো তোকে মানে these are the statement of the villagers, page 14 and page 15. Apart from that, my lord, apart from the relative statement and the complainant statement herself. My lord, Sanjay is the husband, and my lord, 5 of them are before your lordship. The
Is there
father
an
in
injury report?
yes, my lord. My lord, page 6 onward, 6, then my lord, 32 to 33, 53 to 56. Page 6, my lord, kindly sees first. My lord, it's a 498A, 406, 307. My lord,
How many petitioners are here?
my lord, 5 of them, the husband, father-in-law, mother-in-law, brother-in-law, and the wife of brother-in-law.
Materials against all.
Yes, my lord, all. My lord, let the charge sheet be filed. My lord, if they are, my lord, they can also pray for discharge if after getting the papers before framing of charge. My lord, unnecessary keeping it pending here, my lord, won't suffice any. My lord, the police cannot submit the charge sheet. Investigation is over, my lord.
Okay.
My lord,
CD be here,
let the CD.
2 p.m. Huh?
2 p.m.
I will dispose of this case today.
Yes, my lord. My lord, kindly, because my lord, this has been pending since a
Yes,
long
yes.
time.
And there is no merit on.
And no merit, my lord, unless. I asked for Anand Ashwe. Anand কোথায়?
Yes, madam. 7. But I am for the de facto complainant.
Who is for
But
the
I think
petitioner?
in cricket there is a word called dead rubber, which means the match is over. The match is over so far as this matter is concerned. Why? Is because your lordship by a detailed order had, my lord, the reason why the other side is possibly not appearing is because by a detailed order, your lordship had refused the interim order which was granted earlier. Your lordship had vacated it. After vacating the interim order, the petitioners got arrested. They were in custody for a substantial period of time. Yesterday, or in fact, day before yesterday, the petitioner number 1 possibly got out on bail. Now, once he's out on bail, there are serious conditions saying that he cannot enter a particular jurisdiction. Along with that, he has to meet the investigating officer twice a week.
Okay.
So, for the purpose of furtherance of investigation,
Come here against
they have filed for quashing
of FIR or charge sheet?
FIR, and
Charge
the
sheet hasn't-
no charge sheet has not been submitted. Possibly a report is coming because we learned from when we were moving the bail application that charge sheet is about to be filed.
Who is appearing for the
Oh,
state?
sorry, Baba. Sorry.
No, it's a status report only. What my learned senior friends always
No,
state is that
whether investigation completed.
investigation is not yet completed, is on the verge of
Why
completion, my lord.
this is a case pending since 2018.
No, these are old records and it was paused because of High Court. High Court had put a stay.
The entry
Your-
has already been expired or
Your lordship vacated it.
Thereafter they can-
Thereafter, there was an arrest.
Okay.
About 30-35 days in custody, bailed out by High Court. So possibly they need another a week or so to finish off.
So you
week or
file
two.
charge sheet.
My lord, few bank replies are yet to come, my lord. We have already intimated the bank. The replies are yet to come, my lord. As
The-
soon as we receive
Should
the
I
replies from the bank,
adjourn
my lord,
this
the charge sheet will
matter?
be submitted.
No, your lordship can dispose it of on the basis of the status report because nobody is appealing for the petitioner.
CD is not there.
CD is there.
My CD is with me, my lord.
CD.
CD is with your lordship. If your lordship desires to keep the CD, it's perfect.
What is the materials collected during the investigation?
In one word, I'll tell your lordship because we were opposed.
Let him tell.
Correct.
Because he is the state.
No, then, my lord, I will pray for an adjournment because I am led by Mr. Rai Chaudhary. He will be addressing your lordship, my lord. He has requested me to.
There is CD. You
My
come
CD
at
is
2
with me.
PM. If there
I
is
can
material cognizable offense is there,
Yes.
disclosed, then what is the purpose to keep this
Correct.
case pending?
But then let it be at 2 p.m., my lord.
Yes, 2 PM.
My lord, I am ready. Okay.
2
Let it be
PM.
at 2 p.m. I will inform.
First, I will go through the CD and materials. Thereafter, I
Very well. Grateful, Mala.
I'm sorry, my lord. Item number 5 I missed because the board was working. And when I rushed in, then 5 was gone. Lordship has fixed it on 5th of December.
someone from the side of petitioner pray for adjournment on the ground of bereavement.
Then it's all right. Lordship, I have also given my name and under the other.
I have already fixed on 5th.
Lordship. I am appearing for respondent number
You may give your appearance.
respondent number 6. I have given.
Give your appearance.
Fine. I'm deeply. Right. Number two.
Yes.
Item number 8. Lordship, item number 8, your lordship, is appearing for the private opposite party. Requested me to adjourn this matter, pray for adjournment.
Why this is an
I
application?
understand.
What is the application?
This is for
What is
restoration, my lord. This is for
restoration?
restoration. It was dismissed for default.
Okay.
Lordship can restore it. Lordship can fix a date for hearing. I'm ready with the matter today. But if this is illness, I mean,
Already restored.
not restored.
Okay.
Lordship can restore it.
I think it's Monday because he instructed me over telephone that he has not received any application for restoration.
This is my affidavit of service. This is my affidavit of service. I'm filing it in court. I understand that the need.
Once you
I will give a hard copy also. No problem. I will give everything, my lord.
Kindly give us a long time.
next day I will. Yeah.
Very well.
Is there any urgency?
I am paying 60,000 rupees. I have under the DV Act.
Oh, DV Act.
DV Act. And my lord, there is Rajneesh versus Neha is
So
what we
wha-
follow.
once you solve the copy, thereafter
I
I
will,
will fix.
I will give.
The petitioner is
Nine.
Item number 9.
My lord, on 19th September, since the respondents did not appear, Lordship directed us to serve, but I have served, they have received.
I am appearing.
you are appearing
I'm
for the
appearing.
opposite party.
Opposite party, yes. I am the complainant.
Who is appearing for the state
The state is not a party, it's a complaint case.
complaint case.
My lord, my challenge is washing of proceedings in complaint case number 44 of 2019,
Yes.
pending before the learned judge second court at Kolkata under section 129, 448 of the Companies Act, and all orders passed, including orders dated 22nd November, 23rd December, 14th of my lord, Lordship will kindly come.
What is
The-
the allegation against you?
Huh?
What is the allegation?
I am coming to the allegation. My lord, Lordship will kindly come. My lord, page 19.
Yes, 19.
Page 19. Complaint under section 129 and 448 of the Companies Act.
Yes, which paragraph you meant?
My lord, at page 2, they says about contravention of section 129 and also contravention of 448. One lordship will kindly take the paragraphs. My lord, that is against Vishal Sharma, chartered accountant of the company. I am no way related. And again, the balance sheet at 3.2, the balance sheet as on 31st March 2017.
No, company did not make disclosure
My lord,
required to be made according to Schedule 3 of the Companies Act.
yes.
You also did not
My lord,
disclose
I have disclosed everything. Lordship will
disclose the
kindly.
specific bank notes
Huh? My lord,
bank notes during the period of 8th November 2016 to 30th December 2016.
yes.
This is the first allegation.
My lord, that is by Vishal Sharma, the chartered accountant, not me.
Your company.
No.
Your company.
No, my lord, I am Apurva Mukherjee, one of the director.
Director. The director is responsible.
My lord, my chartered accountant has done that. My lord,
Chartered accountant, on what basis chartered accountant do the work on behalf of the company?
my lord, lordship will kindly take. My lord, in similar, my lord,
Not-
of the
next,
same director.
next allegation is you borrow 80 lakhs 54,450,
Yes.
but you did not make any transaction. So you violated 129.
My lord, if
Now
that is
another
so,
allegation is 448.
the company's refrainment from disclosing details of specific banknotes prove serious illegal involvement of the company in regard to handling of SBN.
Company should have disclosed all
My
this.
lord, I have disclosed. Lordship will kindly come to the My lord, page 32. The independent auditor's report.
Where you show me,
My lord, I am showing.
where you have disclosed all those
My lord,
allegations.
for that, lordship will have to come to the balance sheet. My lord, it is at page 50.
Yes,
My lord, lordship will kindly take from page 47.
this is the balance sheet.
Yes,
How
my
you
lord.
can-
My lord, I have
How you
disclosed
can
everything.
show that the specific bank notes during the period where you have shown in your
Lord,
particular
My lord,
accounts?
my lord, that is the chartered accountant show. The chartered accountant has shown that. My lord, this is absolutely a
False
vindictive,
allegation.
vindictive steps taken.
Why specific
My lord,
particular allegation has been made?
my lordship
You
will kindly,
show the court that where you have complied.
my lordship will kindly take this judgment once.
I am not asking about the
My
judgment.
lord, this
First
is
of
my
all,
lord, same on the
revert
same.
the allegations made by the opposite party.
My lord, the same.
There are 1, 2, 3 allegations with regard to the section 129 and another allegations against section 448.
Yes.
Where is that? Show us. Show me.
My lordship will kindly take this judgment on the for the other
Ah,
director. For the other director passed by this honorable court.
Hmm.
My lordship will kindly take this judgment.
So they have exonerated.
Yes, my
All
lord.
directors have
Yes,
been.
yes, my lord.
Whether
No,
they
the
were
particular
active director.
Yes, of
Whether
the
they
same
were
company.
active director.
Active director. My lordship will kindly consider this.
You are also active director.
Huh?
You are also active director.
Yes.
How director can exonerate it
My lordship will kindly see this judgment has been passed by this honorable court
on the same case?
on the same allegation, same case.
Which portion? So
My lord, I do
which
not
portion you are relying on this judgment?
have- my lord, I do not have the বলছি ওখানে নামি জজ সাহেব দিক আমি দিচ্ছি
Have you gone through this judgment?
My lord, I do not have a copy of this. My lord,
You supply this.
yeah,
No, my lord, may I make a preliminary submission as
Defend.
may I make a preliminary submission? Kindly come to our complaint.
What about this judgment?
my lord, I will be handing
Similar
over.
allegations.
Kindly come
Subordinate bench has already exonerated
Yes.
other.
whether the offense was in the same nature or not, that is to be seen.
Absolutely,
Go through.
absolutely.
You have not appeared in that matter.
No, in that matter, I have not appeared.
Register of companies do not appear.
So ex parte order has
This
been
is the
passed.
first time they are coming.
You serve the copy.
I am serving a copy. Lordship will kindly keep at 2 p.m. I will.
No, 2 p.m.
2
now.
p.m. not possible. He has to go through this judgment.
My lord, may I be permitted to take a different view, my lord? May I take permitted?
Asking about you go through this judgment. A coordinate bench already exonerated.
My lord, kindly see the offense committed. This is fraud.
I have already gone.
Concealment of material records. That is fraud under 448 of the Companies Act.
Already gone through the allegation.
At least they should have filed a nil report.
But what
If there is no specified banknote, they should have filed a nil report. That is also not done.
what about this judgment?
That I shall, may I be permitted to
Challenge this
peruse that?
judgment.
May I be permitted to peruse that judgment, my
My
lord?
lord, I am handing over a copy, making a copy. Lordship will kindly keep.
First you submit this. You gone into the merit and thereafter you are showing this judgment.
7 rounds of jurisdictional issues, such as the findings, the authority who had approved the audit, all of those were incorrect on the face of record. A transaction which has been carried in the book for 9 years, and I have reflected from my annual returns itself that this same transaction is
So on,
reflected.
on 2 grounds, you have been
Well,
exonerated.
I had taken 7 grounds, all 7 allowed.
Sub allowed by the
All
court.
of them allowed. And that was done after service on them on 3-4 occasions. Even lastly, before the learned judge, we appeared similar to today.
Okay.
We served, they did not appear. Again, we came back, we served, did not appear. Then the judge passed the order.
Okay, next week I will go through.
I will come back, my lord.
You
No problem. He's
also
here.
go through the judgment and
So, my lord, only the date, and it is by the same complaint, same number, everything. In the complaint, my lord, there were 3 persons. Now the other 2 the other CRR is in respect of the second director.
okay.
So their complaints,
Same self allegations.
only namesake allegations, and only the name will change and the number will change. Nothing else. One director.
Okay, is there any interim order in this case?
No,
No.
my lord.
Okay.
No
So
interim.
what is CRAN 1?
My lord?
What is CRAN 1?
My lord, Can one was my lord, there was an interim order in one of the, there were 3 petitions. One of them, there was an interim order. We had filed an application for extension in terms of the previous order. Now, in respect of the present
Others.
matter being disposed of, and the interim order period has also expired, but we are seeking that if we can have a disposal on the basis
Yes,
of the
yes, we
same
can.
judgment, then we will not press for an
Next week.
interim order.
Let me go through.
In
Let
the
me go.
Next week I will.
March
Around
of
21st.
21st. March of
Okay.
Item number 10 with 11. For 11 is.
Item 11 has been disposed of, your lordship, on 12th of September 2023. I am the petitioner there.
Item 5 of item 11 was called for by your lordship's order dated 26th of August 2025. My lord, kindly says
There are 2
for adjudication, proper
One is
adjudication of this matter, that file was called for.
Okay.
That is a disposed of file.
Your appearance is not at all necessary. Item 10 is quashing of FIR in respect of an offence made out under section 295A, 153A.
1 minute, let me go.
Crux of the allegation is tweet made on the incident of stone peddling on Vande Bharat. Right, my lord?
With
Tweet.
stone pelting.
Stone peddling on Vande Bharat. Now, 10 media persons, along with the leader of the opposition, was arranged as accused persons. 10 persons are media house persons. So, main media house, that is India Today, and one of the journalists, that has been quashed by this honorable court on the same FIR. And therein, they filed an affidavit. If your lordship kindly see their order of quashing, your lordship will be pleased to find the first paragraph. That is why this file was called.
That is
Yes,
12th
first
of
paragraph.
September 2023 in CRR number 265 of 2023.
Yes, which paragraph you are referring? Paragraph 2nd.
Yes. My lord, kindly see. My lord, in paragraph 5 of the declaration, one declaration has been made. That is why your lordship wanted to know what kind of declaration they have made. My submission was that my role is completely independent. As a leader of the opposition, as the member of the parliament, I tweeted about an incident. How could it come within the purview of a penal provision of 295A and 153A? আমার আবার করছিস কেন? যা তো তাই আমার। আশ্চর্য, আমার করে যাচ্ছে।
But this case was quashed due to undertaking given to the state. So state is also
Kindly hear.
Mr. Mukherjee, Mr. Mukherjee was the learned advocate general at that point of time. So Mr. Mukherjee came, the learned advocate general made a proposal that you even undertake that it was not, this tweet was nothing to defame the higher officials or the minister, the CM of the Bengal. So we made
And that was consented by the state.
Lordship. It
But
was
in
only
this case,
consent.
no, whether in this case, this
My
conditions
case is
are
different.
totally
In
different.
my
Yes.
case, my humble submission would be, I made a tweet. What kind of tweet? Lordship, kindly first take up page 22.
So this order is not applicable here.
This order is not squarely applicable,
Yes.
but at the same time, what is the substance of the order? After all, a series of tweets were made. Who made? These journalists made, and the leader of the opposition made, on a particular incident, that is stone peddling on Vande Bharat. If your lordship kindly see, I have annexed all the tweets. Then, if on the basis of all those tweets, when a journalist have been exonerated, why not the leader of the opposition? Isn't it a
You have to
democratic
give,
country?
you have to
Would
give
it
the
come within the
undertaking.
ambit of
Yes,
Patricia Muki?
then you have also give the undertaking to the state.
Yes, I am on that.
And your lordship, may I
I
suggest-
am
They
on
have
that.
given undertaking. That's why
Very well.
state has
What has
accepted
fallen
their-
from your lordship, I have deepest respect to that. But before I made such kind of undertaking, my lord,
Because
kindly
this,
give me
this
chance to hear
judgment
this matter.
is specifically stated, the state has proposed that the outcome of the present revisional application be restricted to the present proceedings
Yes.
and should not be treated as a precedent in other cases.
Very
So
well.
this judgment is not applicable at all in this case.
So,
So far as your
my lord, that is the reason why this
petitioner
file
is
was
concerned.
there. I wanted to know what kind of declaration, what kind of a form of affidavit was filed, because I have no copy of that. I
You
don't have that
approach
copy.
them. You approach them. They will supply definitely. State will supply. What was
Lordship,
the
I have also
undertaking?
not received that copy.
Indian Advocate General was present. It was because of his intervention this matter got resolved. And the learned Advocate General was directed by the court to appear in that matter.
So I also,
If they want a similar order, then they should pray that the matter
That's it.
case of copy be served on the learned advocate with the direction for him appear.
you are appearing for?
I am
He's
for the
for the
petitioner in this matter.
In the disposed of matter, item 11.
So in presence of Advocate General,
Lordship, I was not there, so kindly ask my learned friend to give me also a copy, so that I can understand what type of.
My lord, let him provide me copy. I will hand over copy to Mr. Shur. And kindly fix a date and kindly request Advocate General to appear in this matter.
That direction is already there.
Item 11, because it's disposed of.
No, item 11 has no role here. We wanted to know what kind of declaration or affidavit was filed. That is why lordship was called this.
Lordship, that direction. Order in this matter also. That order was
basis
passed.
of this order, I am asking request the Advocate General to appear in this
Lordship,
matter also.
Let them hand over the
Lordship,
copy.
that order.
Meantime, petitioner shall serve the copy as well as this order.
Definitely.
Yes. Lordship, that order was passed on 13th of March 2023.
13th of March, which court passed that order?
Lordship, that was passed by my lord.
In another case,
No, Lordship, in this case, in present case, which your Lordship, CRR 323 of 23.
on which date?
Lordship, 13th of March 2023. The first order at the motion stage. Ex party order. Lordship will get it at page 3
Yes.
at the bottom. Page 3 at the bottom. On these issue,
There is already direction.
that
Okay,
You give us a copy of the
Since you're
affidavit.
the corporate house, your lordship may kindly just one line that though item 11 will appear in 10 to the CRR system, the accounts are
Though the item
Zero 97 M Sood.
Item number 12.
I am for the
I am for the response, defective complainant, my lord.
Your lordship heard this matter on 17/9/2025, my lord, heard at length. And since on that day, my lord, CD was not available, your lordship directed the state.
who is appearing for the state?
Case right. So the case before your lordship, I paid for quashing of a proceedings, my lord, under section 420, 468, 469.
Vivasan Bhattacharya.
Yeah, keep
Yes,
it, my lord,
Mr.
next.
Kaur. Who is appearing for the state?
Vivasan and Raju Mandal.
Kasip, kindly mix short pass over. Just now he has gone to code number 8. One matter has been called on. He was waiting here for this matter.
Okay, pass over.
Pass over.
Keep it 2 then, my lord. 2 p.m.
Not today.
No, my lord. Keep it 2 p.m. then, my lord.
2 p.m.
Okay.
Okay. 2
Then,
p.m.
my lord, 2 p.m. Not today, we make it not today. When since my lord directed us to produce the deed, my lord, which we have today, I have my lord, missed the deeds, my lord, on the basis of relying, my lord, we have my lord,
There
filed
was
the
no
complaint.
Is there any direction for
No, my lord,
production of?
no, when I verbally, my lord, asked my junior to
All deeds I have.
then, my lord, they,
All deed I.
Keep it not today.
Not today.
That even
I'm waiting.
my lord is.
Not today. Next day I will take up this matter.
Can you fix the time?
It is
my lord? Otherwise-
already fixed at top.
My lord, very well.
Retain the same position.
yes,
Get followed.
great.
Item number 13 with 14.
Yes.
In that matter, my lord, proceeding has already been passed, my lord. My lord, kindly see the order of 19 September 2025, my lord,
Quashed by which court?
passed by this High Court, my lord.
Another coordinate bench.
So, the proceeding of Quack, kindly looks at order dated 19 September 2025, my lord. My lord, from the report which was given by the state, my lord, said that the case diary is accessible now. And after that, my lord, your lordship had ordered that record must be recorded. And my lord, today the state is not present.
Another revisional application has not been annexed.
My lord, it is appearing as item number 14.
You are here, petitioner, on Anamika Bhattacharya. And Amanat Ali, who is Amanat Ali?
Was one of the co-active parties. They had prepared a quality application manner, and in that quality application manner, trustee has already been passed.
Yes, what is the stand of the state?
Madam, for the state. On the last occasion, your lordship called for another CRR.
Have you gone through the judgment passed by the coordinate bench?
Yes, yes. I have gone through, my lord.
So the similar applications,
Similar
that
footing.
is also applied to him also.
Yes, yes. That is why, my lord, on the last occasion, I said, my lord, kindly call for that CRR. I have seen, my lord, order. I leave it to your lords.
This judgment.
My lord.
Do you agree with this judgment?
My lord, whatever record I have seen, my lord, the FIR, the allegation is similar. A person committed suicide, my lord, the petitioner for your lordship is wife, and my lord, the another person who has been, whose application has been quashed, that is the brother-in-law.
You have annexed charge sheet.
Yes, my lord. Charge sheet also, my lord. So for plain reading of the first information report, only allegation is that there is a illicit relation with this petitioner who has been, my lord, acquitted from this case, discharged from. My lord, otherwise, there is no allegation so far abatement is concerned.
Which page the PM is also there?
Yes, my lord.
PM is also there.
PM is also there, but my lord, observation is that it's not conclusive.
My lord, that was page 32. I have annexed, annexure P3. My lord, final, my lord, opinion, my lord, for the Vichera not yet come. There is no opinion whether he actually.
More or less 1 month later, FIR was lodged.
Yeah, yes, my lord. Subsequently, later, there is no my lord, explanation so for filing of the delay in FIR. One of plain reading of the FIR, there is no allegation so far 306 is concerned.
There is no allegation against R.
No allegation.
Have you gone through the complaint?
Complaint,
Page 25.
Was having illicit relations with one staff, Sri Amanat Ali.
Amanat Ali already has been acquitted from this my lord, CRR with the Quas,
And you are Anamika Bhattacharya. Who is she?
the wife of the victim.
she is the wife and another who has been acquitted, quashed, that is brother-in-law.
Brother-in-law, illicit paramour. Allegation.
That is sufficient for initiating a proceeding.
Charge sheet has been submitted, my lord. If your lordship thinks that this person stands on similar footing, my lord,
During investigation, anything revealed.
my lord, that
With
is the
regard
difficulty,
to
my lord.
With regard to the section 306,
Difficulty is that, my lord, that statements which has been collected in course of investigation, that
who
is
will give the statement.
that copy, my lord,
We are nothing.
nothing, nothing.
Any hand notes found during investigation?
No. That is.
What about the CD? Where is the CD?
My lord, CD is missing, my lord, in spite of repeated order by this Honorable Court, Justice Tirthankar Ghosh. My lord, it was not been.
Earlier occasion,
My lord,
when my lord, it was heard out by the another bench, also my lord, on that point of time, CD was not found.
CD was?
Not found.
So what is the remedy now?
What is co-accused and so far plain reading of the first information report, no allegation so far 306 is correct. And whose main allegation against Amanat Ali, Amanat Ali's pair allowed by this honorable court and caused the proceeding. I am the co-accused.
Let the PP come.
public prosecutor.
Your Lordship, I am appearing on behalf of the opposite party, my Lord, ROC. Now, prima facie,
Whom your lordship heard this matter. Hearing was
দেখো
started.
স্লিপ টকে
Today
দাও
we are on
দেখে নাও
November.
নাম আছে কিনা
We need to
দেখে নাও।
discussion, then we need to further substance. These two are literally Gondomata. Before my lord.
So that I understand, but my
My
only
lord lost his opposition.
one of the that I told. Now they will supply in course of this day. Well, only one thing I beseech
So
your
what
lordship.
do you want?
Your
Today,
lordship.
what do you want?
They kindly fix a date for hearing. And
Pleadings are
Date.
pleadings are
Date
complete.
itself is a date for hearing.
today, since he lost his opposition.
No,
he
that is no
requested
ground.
to supply
That is
opposition.
no ground. If he wants time, that's fine. Because I have lost one of my copy of my opposition, that is no ground. If they want, they can start. I will give reply.
Yes, you can start. This matter is fixed.
That is no ground.
Mr. Ganguly.
Then you come with. Then you come with that. Mr. Ganguly has difficulty. That I understand.
No, not difficulty. Engaged in
There is
Only,
cran.
only my
plan is for extension.
extension. Fine, my lord. Only.
Complaint case, both these two cases are complaint, 15 and 16.
My learned friends allows me once. My lord, the thing is that I have no difficulty, my lord, if a date is fixed. But the thing is that this matter, my lord, is pending since 2020. And my lord, they have come against, my lord, just filing an appearance of these allegations under the Companies Act. Prima facie case has been made. That will be our submission.
You can start.
Issue is 32.
Can you start?
Pawan Kumar, 840. Your lordship has already.
863. Pawan Kumar.
Your lordship has already heard on 20th June on the score of 32A of IBC. My lord is a book of IBC. Here.
Yes.
Now, IBC, this 32A amendment was made just to secure the persons, the directors, and the companies who are erstwhile, not after moratorium, in terms of section 14. That is the intent of the legislature to incorporate 32A. Your lordship kindly take first section.
First of all, you come to the complaint.
Offense.
Please come to the complaint. Where is the complaint?
Complaint. Petition of complaint is at page 27.
27. Yes.
Now, kindly take note of.
You are here.
Cost title.
You are here. All the accused. Only Divyajyoti.
I am here only for the company. In CRR 840, Malad has taken up 840.
Yes.
In 840, only Divyajyoti Sponge Iron Private Limited is before your lordship.
Okay.
Now, in page 27 is a complaint. Malad,
Is there any another matter?
Yes.
Where is that?
That is 863, item 16.
Oh, item 16.
Yes. These directors in item 16, they came later after moratorium.
Okay. So both should be heard together.
Yes. One after another. One after another. These two are related. One is the company.
So you come to the complaint first.
Now, in the petition of complaint, my lord, paragraph 1 is the accused 224 herein are directors, officers. Kindly take note of the word. Para 2. Directors / officers in default of the company.
What does it mean, officer in default of the company?
Now, here a company X, they faulted. There are a lot of dues in the market. The creditor moves before the company law court in terms of section 7. Once section 7 application is admitted, then means that date is acknowledged and admitted.
Okay.
Then that moratorium comes up in terms of section 14.
Thereafter, yes.
What is moratorium? Then secured creditors comes into play under the aegis of NCLT upon appointment of resolution professional. So there is one resolution professional that has been appointed by NCLT. Then all secured creditor would come. Then a new company would have formed. That new company is before your lordship. So 32A IBC legislated with intent to protect new one, not for previous offense that has been committed by the erstwhile company.
So Sunil Jain, Anil Jain, and Gauri Shankar
These
Jain
are
was
the officers in
earlier
default of the erstwhile.
director. Okay.
Whoever are before your lordship in CRR 840 and 863, they are the new incumbents. They are the incumbents that they came after the moratorium. How could they charge for alleged offenses?
So you are here, company, and in another
840,
another
863, the director.
Who are they? Who are they?
এই ফাইলটা দিন, ওই ফাইলটা দিন, এই ফাইলটা।
Pawan Kumar Kajriwal.
Yes.
All the four are different name.
Yes.
No, no, it's not correct. If you look
Complain
in the complaint,
have alleged against
জজসাহেব তো আমায় জিজ্ঞেস করছেন
all these
My
four
lord.
persons. One minute. 1 minute. 1 minute. I am asking you
Yes,
whether these four directors are the accused in that
my lord,
case.
I have the copy of one opposition. My lord, so far the second matter goes, that is CRR 863 of 2020, Pawan Kumar Kejriwal. We have filed opposition and reply has been served. In opposition, my lord, we have stated, my lord, in paragraph 4,
So one another complaint has been lodged.
yes,
In
if
that
your lordship-
complaint, Pawan Kumar,
Kejriwal,
Shyam Bihari, Naresh
yes, if your lordship,
Kumar, Nikhil Nathani, Anil Kumar Tiwari, and others three.
yes, now your
Earlier
lordship,
three directors were also.
coming to that, I'm coming to that. Your lordship, kindly once take the opposition of CRR 863 of 2020. There in paragraph 4, page 2, we have indicated that when the directors were appointed and when they have worked in the said company, when the offense was committed, the directors were
My
very much.
question is whether the subsequent director will be held liable for commission of offense prior to that.
I will give answer, my lord. Let me check. I will give you answer. Let him complete. I will give reply. I will give reply. I understand what fell from your lordship.
Because they were not existence at that point of time.
My lord, I have to
When
check.
earlier,
I have to check and I have to submit because today I'm in that matter handicapped. I don't have the opposition. So far, the next one is concerned 863. If your lordship for once takes the opposition, once take the opposition. 863, the next one.
so I am fixing another day.
Very
You
well.
prepared yourself. Otherwise, it
No, I will
be very-
prepare. Your lordship kindly directs, my lord. I have repeated, ask my learned friend. I have lost, unfortunately, that.
You hand over one copy.
This day will hand over.
No, that's not correct. My lord, she is
once
an
again,
officer of the
provide-
court. She has provided me, which has been not pressed. Let me fair. Both of us, let me fair before the
Having
lord.
heard the service.
First, we are the officers of the court. Yes. Now, lovely to তুমি মেরে fair টামি নি।
Having heard the submission of the learned counsel for the
My Lordship, Advocate Nanigopal Chakraborty for the
Please
petitioner.
speak louder.
My Lordship,
State.
the petitioner, I beg for not to.
I beg.
Why? Why not today?
My Lordship, I am not in this matter.
Last occasion also prayer made from the side of petitioner.
I am not in this matter.
Why you have not take proper instruction?
My lord, I beg to
You
appear
have take proper instruction.
on behalf of the opposite party number 2.
Hmm.
They are supposed to serve on us. But that order passed by this honorable court on 21st March 2025, my lord. I have not received any copy. They have served only that disposed can. Yes.
Already
that has been
restored.
restored. It has been restored. After that, my lord, they have served this cran. I have only, my lord, received this one, not the, my lord, CRR.
You serve the copy.
Yes, let them serve the copy because I think my learned friend will have something to.
Yes, that's
The learned counsel appearing on behalf of the you inform your companion to supply the copy.
18.
Lord, item number 18, and for the petitioner, my Lord. My Lord, Mr. Komi Ganguly is appearing in this matter. In very recent, his father passed away, my Lord.
Yes, yes.
Praying for not today. Only not today.
Not today.
It's only not today.
So other matters were fixed in the month of December. So how he will come?
By the next week, he will available.
Next week he will available.
Yes, yes.
But not this week. Just
19.
For the petitioner. But this crossing of FIR and charge sheet, my lord. But what happened?
You are for the state. Please come right side.
Unfortunately, my lord, I don't have the case diary.
You do not have case diary.
Whether your lordship will require the case diary, my lord. Crossing of, my lord, this is a civil dispute, my lord. My lord, arising
Without
out of
TD,
a
how
contract.
can I go through the materials?
It's squashing of the charge sheet, my lord.
But
until-
FIR and charge sheet, my lord.
Maybe, but other materials should be looked into.
But then,
161,
give me
164.
my opportunity to bring that, my lord. Only, my lord, my one application is pending, my lord.
Let the CD comes, then I will decide this matter. Where is the problem?
I'll call for this.
One
Which
application.
section?
This is 420.6. Between two business houses, I feel he has annexed few documents. So let us have a look at the charge sheet. Why charge sheet was filed and the other materials collected.
420 and 406, 120. What is the allegation? What is the allegation?
Yes, my lord. My lord, I am, my lord, a consultant service, my lord, provider, my lord. My lord, provide service, my lord, to this West Bengal housing for this WPCST, my lord, for giving environment clearance. There was a contract, my lord, between me and them, my lord. Total amount is to be paid, my lord, to 18 lakhs to me. Out of which 3 lakhs 20,000 is, my lord, mobility advance. Mobility advance means, my lord, that I don't have to refund. Now their complaint is this, my lord, that I am not, I have worked, but I have not worked satisfactorily. That's why they want that 3 lakh 20,000 to be refunded to them. If I do, just because I have not refunded to them, they had filed this application, my lord. Now the contract said, my lord, that 3 lakh 20,000 is not refundable. That is executed between me and that
already in terms.
in terms. I will show that also, my lord. And in FIR also, my lord, your lordship will find, my lord, that no cognizable offence has been made out, my lord. From that point of offence, my lord, your lordship will not find that there is any mens rea to cheat the person, my lord. Now, if your lordship wants, my lord, your lordship can first come to the
Who is
FIR.
appearing for the opposite party number 2? Have you solved the copy?
My lord, copy has been served, my lord, they are appearing, my lord. Your lordship will also find, my lord, one can application 6 is pending, my lord. There, my lord, there are several.
And opposite party number 2, commercial manager. Whether have you solved the copy?
Yes, my lord. Serve the copy and also, my lord, serve the application or this my affidavit service. Your lordship can see the affidavit service. What I have served to, my lord, the public prosecutor and also, my lord,
Earlier, someone appears on behalf of the OP2.
Followed on order dated 17th
Sharmishta
of-
Ghosh.
Yes,
Yes,
Mr.
madam.
Shormishta
The
Ghosh.
Section Mondal and associates are appearing, my lord, for the private respondent, my lord.
Okay.
But I have served them, my lord. Your lordship can see the affidavit service, my lord. I have served the application also.
Yes. Is there any interim order?
Yes, my lord. Interim order is there, my lord.
The CRAN is also pending.
Can, my lord, it's also.
The interim order already expired in the month of
But they had filed within time.
2025.
Within time, we have filed CAN 6, my lord. That is
CRAN
pending.
6,
Can-
CRAN 6 you have filed within time.
They had.
But it expired, my lord, on 30 August 2025. But we had filed, my lord, on 21st August 2025.
Okay, within time.
Within time, my lord. I'll pray before your lordship to allow that, my lord.
So when CTV available?
That gives me at least 1 week, my lord.
1 week.
Extends this, fixes it.
Extend a limited extension, my lord, and fix it, my lord. I have
এটা এসে গেলে ready করো। হ্যাঁ, হ্যাঁ, এই।
22 to 23.
Your Lordship, I'm here for the petitioner in revisional application number 3169 of 2023. Your Lordship, I am praying for a short passover, Your Lordship. My counsel was waiting here, but right now he's on legs.
What
in
is the
36.
case about?
It's regarding an FIR which was lodged by the aunt against my
which
client and
section?
again
Under which section?
385, section 355, 506, 300. So basically, it's my extension application, which is grant 3. So, Your Lordship, kindly grant a short pass over
Grant 3 is
for extension of an interim order.
You are not ready in the main matter.
I'm ready, Your Lordship, but still I want a short pass over, Your Lordship.
Short pass over. Okay, short pass over.
Hello, Mr. Anwar Hussain is appearing for state in this matter. He is taking court number 28. But I'm praying for not today.
Not today, why?
Not.
Please speak on mic.
My lord, the advocate appearing on behalf of the state, he is in court number 28.
Pass over. I have already passed over. Ask him to come. Ask him to come.
Then kindly fix it on 2 p.m.
2 p.m. Okay, 2 p.m. if time available.
2 p.m.
2 p.m.
2 p.m. I think Your Lordship has fixed another matter today. 2 p.m.
Yes, 2 p.m. I will
My lord, I am
call one by one.
My lord, I am here, my lord.
One by one I will call.
For this matter, my lord.
Other side is not available.
Yes. May I just appraise your lordship of two things, my lord?
What is the purpose of appraising?
But the only
When
difficulty is, my
no
lord,
CD, no other side.
the only
Why should
difficulty
I
is, my
hear
lord,
you?
my
Wasting of
interim
time.
order has lapsed, your lordship.
I will hear it
Very well. Then
at 2 p.m.
Very well. Then your lordship takes it up at 2. Very
2 p.m.
Very well. 2 p.m.
Your Lordship, I am appearing for the petitioner 1 to 4.
CD is available. Is CD is available with you? $409.
409, 420.
34, 120B. How many petitioners?
4 petitioners, Your Lordship. 1 to 4. All of them are State Bank of India officers.
All are?
All are State Bank of India officers.
Okay. Is there any interim order?
There is an interim order, Your Lordship, that no coercive action should be taken against the petitioner.
What about the investigation?
Instruction will not fix a date.
You are saying CD is lying with you and there is no instruction. You see the CD. What is the stage of the investigation?
Your Lordship, this is a very interesting case. If I may allow 2 minutes to submit my submission, Your Lordship. There are 2 FIRs on the same cause, Your Lordship, on the same SBI officers because they demanded the loan back. The account has gone NPA to the tune of 8.4 crores. When they sent the demand notice, there are 2 FIRs lodged against these 4 individuals, saying that they have conspired against the data.
Similar allegation. Similar allegations.
Similar allegations.
Both
of them that they have
There is
conspired.
another applications.
So same application for both the FIRs, question of both
FIRs.
Yes, Lordship. Yes, Lord.
Yes, start. You can start. Madam, you note down.
Shall I?
Yes,
Lordship. Lordship, this is a typical case of double jeopardy, wherein 2 FIRs have been initiated after filing 2 applications with the learned ACJ Malipur, and FIR number 506 of 2023 and FIR number 854 of 2023 registered with the Bishnupur police station.
One is 156 clause 3.
Lordship.
On the
Both
basis
of
of
them under 156 clause 3, Your Lordship. Both of them, Your Lordship.
Okay.
Because police was not taking the FIR because it's a civil case. If they have
You are
any
seeking here only one FIR.
No, no, Your Lordship, both the FIRs.
854. In your cost title, you come to your cost title, page number 2. You have written only one FIR.
Your Lordship, on the first page, FIR 506 is given on the second page and quashing of FIR number 850.
Okay.
Both of them are mentioned, Your Lordship. And both the FIRs are annexed, the original copies, Your Lordship.
No prayer is been made from the side of IO to tag both the FIR?
No, Your Lordship, we have not.
Because both 156 clause 3.
But on a separate time frame, they have been lodged. On a separate time frame. not
Maybe,
together.
but IO is there.
Lordship,
IO may have knowledge about the 2 FIR.
Lordship.
Okay, proceed. Proceed your case.
So, Lordship, the opposite party number 2, who is the complainant in the FIRs, it's a private limited company which was sanctioned a loan of 11.3 crores for development project. The sanction
You directly come to the complaint. You directly come to the complaint. Where is the complaint? Have you annexed the complaint?
Yes, Your Lordship.
Where is
Lordship,
that?
since the originals are not numbered, I have numbered the FIR one more copy, so it is easy to go through.
No, you have not annexed with.
The original is annexed at the top, but we cannot number the original. So I have numbered the same copies. I have numbered for easy maneuver, Your Lordship.
Although I'm not in this matter, but since the learned public prosecutor just informed me, may I just raise a preliminary objection, my lord? The petition seems not maintainable because there cannot be two prayers for two washment of two proceedings in the same petition as per our appellate side rules. They cannot be. He has to pray for
Two separate revisional applications.
he has to pray for two separate CRAN applications or make one prayer in a petition. He cannot pray for washment of both the proceedings in the same.
But the subject matter is same.
Maybe.
Maybe.
But there are two
different.
proceedings,
The
two
appellate
different
side rules
dates.
do not permit, sir. The Calcutta High Court appellate side rules do not permit quashment of prayers of two proceedings in the same revisional application.
What about your
He
answer?
has to
I'll have to abide by that, Your Lordship. But if I can, the subject matter is same, the cause of matter is same, the complainant is same, the people accused persons are same. If that can be taken into consideration, but if there are rules, we have to abide by the rules. I will have
Rules are there.
Lordship.
If you challenge two proceedings,
Lordship.
you cannot challenge in one revisional application. You have to challenge in different revisional application. That both may be hard together. That is different.
Yes, Your Lordship.
Can be tagged together, heard together, whatever. But he has to.
Should I dispose of this case?
He has
Kindly,
to
kindly, Your
file
Lordship.
fresh.
I will withdraw this one, Your Lordship, and then file a fresh one. Your Lordship, may I be allowed to file two CRAN and then take
You
it
can
further?
file subsequently. Where is the
Lordship.
problem?
Kindly grant us some time, Your Lordship.
Within 5 minutes, I'll come.
আমার একটা জেরক্স কপিটা আছে ফাইল একটা আমার জেরক্স কপি আমি দিলাম Your Lordship, Your Lordship, for this matter, I am praying for 2 week accommodation, Your Lordship. The advocate is appearing for the petitioner has been affected from the conjunctivitis in both eyes, Lordship.
Not this week or
2 weeks accommodation, Your
2
Lordship.
weeks? The learned counsel appearing on behalf of the petitioner. Right.
প্রাণ দুটোতেই আছে,
26, হ্যাঁ?
একটাতে প্রাণ 7 আছে, একটাতে প্রাণ
One
My lord, I am praying for time. My lord, today, my lord, my clerk.
28. Why?
My lord, today my clerk missed the brief. My lord, kindly
So
wonder.
what answer you will give to your client? None appears on behalf of the petitioner earlier occasion.
Last two occasion, my lord. Kindly see last two occasion.
In this way, I will not adjourn.
My lord, last chance.
What kindly?
My last chance, my lord.
This is the third time.
My lord has last chance.
No, no.
My lord, today we don't
Proceed.
have the brief, my lord. My lord, kindly, my lord.
This is very simple matter. 138.
My lord, kindly.
Not today.
Lord, kindly recorded my last chance, my lord.
Acha,
And
likho.
record the order,
Huh?
my lord.
On the prayer of learned counsel appearing on behalf of the petitioner. Let the call matter be called.
Item 29.
Lordship, I'm appearing on behalf of the opposite party, Lordship. I'm led by Mr. Ronajit Roy.
Who is appearing for the petitioner?
I'm for the petitioner, my lord.
And you are for the OP.
Yes, Your Lordship.
Yes, what do you want?
I'm being led by Mr. Ronajit Roy, Lordship. The application is very short. They are asking for inclusion of some documents, but my instruction is already the argument stage has
Inclusion of
started.
document.
311 was rejected. It's a 420-406 case, my lord. Where 311 we have filed that to rejected on the ground of delay. I mean, we are the complainant. This is a complaint case. So, my lord, certain documents we want to add you.
But Lordship, the argument has already started. The argument has already started.
Can be even after judgment.
But the 311 was considered. The evidence was
Before pronouncement, my lord. Even if the matter is kept for judgment, 311 can be filed.
No, what document you want to?
The main transactional documents were not produced, my lord. The transactional documents were not produced before the court. Now, my lord, that was.
What is the case about?
My lord, the case was, my lord, there is a decree by the civil court, and my lord, which was, my lord, not being complied with by the opposite party till date, my lord, the accused person. So, my lord, there is a 420-406 was also filed, my lord. I just.
Filed by you. Filed by you.
Filed by us, my lord. Then, my lord, after witness action, my lord, we have filed this application on the reason, my lord. The transactional basis, my lord, there was a transaction that we have supplied goods, money not paid. The documents were not adduced in evidence.
So that is your fault.
Exactly. Your lordship is absolutely
fault
right.
cannot be cured.
My lord, R is human, my lord. That your.
May be human, but there is a sufficient time given to you.
Your lordship.
At the time of argument, when you realize that there is some lacuna, how you can?
This is not lacuna, my lord.
How you can fulfill that lacuna? Please come to you the order.
My lord, kindly comes to order dated 10/4/2024.
Yes.
Now, my lord,
10-4.
But 10/4, my lord.
10-4, yes.
But I think it is the second last page of your lordship.
Yes, yes.
My lord, the purpose of inclusion. My lord has seen the last page. Sorry, last para there.
Yes.
Because prior to that, the submission, my lord, I don't trouble your lordship. The purpose of the inclusion of 311 in the statute is to ensure that the essential evidence may be brought on record for the interest of justice. However, the witness cannot be recalled to fill up any lacuna in the case of prosecution.
Yes.
Kindly mark this case, my lord.
Yes, yes, lacuna, yes.
But Rajendra just says the otherwise. I'll just show that. In our case, not only does the petition lacks any clarity about how the mentioned documents shall be brought on record, but also appears to be a clear attempt at the improving upon it by filing lacuna already pointed out by the defense during trial. However, this court fails to find merit in the submission of the complainant's lawyer
failed to place the evidence before given, that at least 4 prosecution witness on record was finally examined way back in 2015, and the complainant made no effort to rectify the situation till date and fix for argument. Under these circumstances, this court is not at all inclined to grant this, my lord. So therefore, first thing, my lord, the argument was not open. Now I just show, my lord, the judgment which was relied on by the learned judge. My lord, learned magistrate, my lord, learned trial magistrate has in fact, my lord, applied the judgment in reverse direction.
ना सर नहीं मैं तो
The advocate on record has not come, my lord. I have the other judgments to show. That particular judgment I don't have, but your lordship will give me a moment's time. Because, my lord, this is absolutely settled by your lordship.
No, as per your own submission, those documents are the vital document that must be produced from your side, but you fail to produce.
Your lordship
And
started
whenever the defense has taken a plea, at that stage you feel, yes, that document should be incorporated.
Now,
How
my lord,
it is possible?
my lord, kindly seize this, my lord.
May I
Your
have
lordships were your lordships in the Supreme Court, my lord, were gracious enough, my lord, as your lordship is also. এই তো দিচ্ছে, এই যেটা ওখানে রিলাই করেছে। My lord, sees the judgment. This was, my lord, relied on by the learned judge, magistrate. Now, my lord, sees para 7. Kindly comes to para 7. It was also a case, my lord, where it was prayed, my lord, at the time of.
No, at any stage this can be allowed, but not
my lord,
for fulfilling the lacuna.
My lord, may I just get, my lord, 30 seconds? Please allow me to place 2 paragraphs. Para
Definitely
7.
I will allow.
It is the common experience in criminal, my lord has got,
Yes.
criminal courts that a defense counsel would raise objection whenever courts exercise power under 311 of the code or under 165 by saying that the court could not fill the lacuna in the prosecution case. Similarly here, my lord, a lacuna in the prosecution case is not to be equated with the fallout of an oversight committed by the prosecution is not by the public prosecutor during trial, either in producing relevant material or in elicit relevant answers from the witness. The adage "R is human" is the recognized of the possibility of the making mistake to which humans are prone. A corollary of any such lacuna or mistake during the conduction of a case cannot be understood as a lacuna which can be filled up. Lacuna in the prosecution must be understood as the inherent weakness or a latent wedge in the matrix of the prosecution case. The advantage of it should necessarily go to the accused in the trial of the case, but an oversight in the management of the prosecution case cannot be treated as irreparable lacuna. No party in a trial can be foreclosed from correcting errors if proper evidence was not adduced or a relevant material, kindly cease, was not brought on record due to any inadvertence. The court should be magnanimous in permitting such mistake to be rectified. After all, function of the criminal court is administration of criminal justice and not to count errors committed by the parties or to find out and declare who among the parties performed better. But just the opposite, my lord, as your lordship is magnanimous, my lord, it's time and again, my lord, Honorable Supreme Court has also said, if there is a relevant document somehow could not be produced, that can be rectified during trial. My lord, I do understand and admit, my lord, as a counsel also, my lord, there was a fallout. No doubt about that. There was error on our part. But my lord, this error is something, my lord, which will stand in the way of arriving at a just decision. And my lord knows, my lord, the purpose of law is the success of justice. So there will be a sabotage of justice unless these documents are produced, my lord. So in this judgment, my lord, which was relied on by the learned trial magistrate, the Honorable Supreme Court allowed 311, my lord. Even at the fag end of the trial, since the relevant document was not.
This case is not matched with your case. Your documents are the vital document for
In this case also,
initiation of a criminal proceeding. You rely those documents.
In the case
you
of
did not produce.
But in the reported judgment, that CFSL report, which was a crux, was
that is from the side of the prosecution.
Prosecutor, my lord.
You are prosecution.
I am the prosecutor
but in your case is based on document.
My lord, kindly appreciate one thing. 311 for evidence.
Long pendency.
But in that case also long pendency. Well, 23 years delay, your lordship's condoned in the Honorable Supreme Court.
Maybe.
But if your lordship wants, I'll just prepare a short one-pager note with the judgment and file on the next day. Then
Your
your
lordship,
will
may I
get my
just beg
dear
to
friend.
file an opposition to this, lordship?
What
Yeah.
opposition you will
Or
file?
a day's time, lordship, to get.
Perfect.
Let me just
File your written notes of argument.
notes of
if you want.
argument. And may I
Next
be
Friday, your lordship will excuse me, any date beyond next Friday.
I already heard.
But only I'll satisfy on that matter, the delay. Because I tell your lordship,
Delay as well as lacuna.
my lord, 2020, but there is a VN
4
judgment.
witnesses has been examined.
Right, only this document.
Hmm.
But 16 years delay was condoned. 16 years delay.
No,
My lord,
that
my
is
lord, I just
case
tell your
to
lordship.
case depend upon.
Your lordship is right. My lord, that crux is whether this document is relevant. Number two, whether I'm adducing any other witness to improve the case. Number two, this is the document which was the transactional basis. Now, your lordship is right in saying that why don't you
Whether that documents were
with me?
stated anything about that document
Transaction.
in your examination
Exactly, but the
earlier.
document was
So
not.
why you have not annexed those documents?
My lord, that's the difficulty, my lord. That was not done properly in the court below, my lord. That's the difficulty. Now, my lord, today, if these documents are not made part of record, my lord, I'm going to lose the case. So, but it's not a question of losing or winning. The crux is, my lord, whether a just decision will be arrived at. I'm resting your lordship's decision on that. Well, next day, I'll just take 5 minutes. I will satisfy your lordship on the delay and the just decision. Then your lordship will hear my learned friend and your lordship will pass.
Both should file written notes of argument because I will decide this case
Only, my lord, your lordship will give me a date beyond, my lord, the next Friday.
Friday after.
Beyond next Friday, but the next Friday, I have some meeting.
Having heard the
ওষুধ খাও প্রতিদিন প্রচন্ড আমার this was heard by your lordship,
My lord.
a very short issue. It's my learned friend's turn, my lord. I'll just take 30 seconds to just, my lord, freshen up your lordship's mind. It's a proceeding under, my lord, 406,
409?
409 of the Indian Penal Code for
409.
406 by the
406 or 409?
Both. When both cannot go together, but that's not the brownie point I have. But this was initiated by the enforcement officer.
No, you are employee of.
We are the employer. It's a provident fund due, belated payment.
Okay.
I am covered by your lordship's judgment, that for belated payment, if the payment is done, continuance of proceeding will be an abuse of process of court. Your lordship has passed an authoritative judgment on this, my lord. We had also filed it, my lord, earlier, right? We have filed earlier a short, my lord, compilation with, my lord, Honorable Supreme Court's judgment. Your lordship has taken care of all these judgments, my lord. And
they have filed their complaint after expiry of
before filing.
468 is attracting.
No, it's only 406. But
468 is
468 is not attracting. But, my lord.
So in this case, 468 is also attracting.
In this case, my lord, deals with the 468, the limitation period, whether the limitation period will run or not. This is the crux of the matter which was passed by this court. In the relevant positions come from para 5.
That was the order of taking cognizance.
Yes.
My lord, kindly comes to your lordship, my lord, or the judgment, my lord.
No, no, please
My lord,
highlight
may I-
this
may I-
point whether this judgment is applicable
No,
to this
no,
case
no,
or
no.
not.
In this,
460 it is not applicable.
not
my lord, per
applicable,
se.
not
But
applicable.
my lord, part subsequent payment during proceeding my lord was taken into consideration. My lord, I have given other
In
judgments.
those
also.
cases, some instructions.
Some
from
instructions
your
was given from
higher authority to
higher
withdraw
authority.
those cases.
Yes,
No,
in
no, no, no. In neither of
No,
those
no.
cases.
To the
My lord,
department.
Right.
to the department, but this
To
is
the
not,
department, if there are so many cases are pending,
and
you
if
have paid to the employees. Now, some meeting was held.
right, absolutely
Some committee was also formed to withdraw those cases.
right, absolutely,
So
my lord.
what steps you have taken from your side? This judgment I have mentioned each and every aspect.
My lord,
This does, my lord, absolutely, my lord. This does not relate with that kind of scenario. This
No, no, my lord, this was
subject to
passed in this case. তোমাকে
Wait,
বলেনি?
wait.
No, no, sir, this has happened in this case only. What has fallen from your also, I don't think my dear friend is instructed, has a proper instruction. Kindly seize this
You
document. my lord.
showed the copy to him.
I'm just giving, I just show one paragraph from this, my lord. Is their document only? তোমরা করেছো, দেখো না। My lord, kindly comes to the last page. Third line from the top, during the course of inquiry.
This page.
My last page, my lord, kindly.
Last
of
page,
it.
yes.
My lord, third line
Now,
from the top.
therefore, start
I'm
paragraph.
obliged.
Start,
Now,
yes.
therefore, I, such and such Regional Provident Fund Commissioner 2, in exercise of power conferred upon me under Section 7A 3A of the Act, hereby conclude that 7A proceedings ex parte and determine that the amount dues in respect of such and such towards the scheme framed such and such, as per the details appended in the following table, out of which establishment has already remitted the whole amount by submitting two demand drafts explained above without generating ECS for the relevant period for which the department could not credit and relevant share of the contributors to the contributions to the individual members' provident fund accounts. The establishment as well as the persons responsible is hereby directed to file ECIRs for relevant period for inquiry for the period of such and such for effectual credit of the relevant respective members account by the department. So now the department, and then my lord says due deposit balance.
But it deals with only this case. My lord, what has fallen from his tweet with a certain facts of cases, I still remember, which was, with direction was given, certain cases were there in which if
the entire case is nil.
না না এটা নীল, এটা নীল, এটা তো বলছে না, এটা আরেকটা বলেছিলেন।
আচ্ছা নয়, এখানে বলছি,
এখানে
এখানে নীল পুরো দিয়ে দেওয়া হয়েছে।
in this case, my lord, the only contention, my lord,
yes,
my lord, but in these circumstances, my lord, initially an FIR was made under section 406 and 409. Thereafter, they have gone for anticipatory bail and they have given the amount. That is the fact, actual fact of the story. Now, my lord, the only facts is that they have given a compilation with regard with some judgments, where it has been ascertained that whether 400, 406, 409 or 420, 406 will lie or not. With that aspect, certain in the Rajiv Jajuria's case, let us distinguish these judgments. Well, has got these compilations.
When you have given compilation,
My lord, they have
But
given.
there are two compilations, my lord. And this is part 1 and part 2.
hey, compilation.
But this was had by your lordship long back.
Compilation.
এটা আমি রাজীব জাজুরিয়া, হ্যাঁ রাজীব জাজুরিয়া।
This is 3618 of 2007.
I'm obliged, my lord. I'm obliged.
There is no any compilation.
But there is another compilation.
My lord, case list, well, it's like this. Part A, deposit of PF post prosecution of a case will entail quashment. But I have
একটা কপি হবে
তোমাকে দেবো।
ঠিক আছে দিও না
তুমি তো জানো সব। My lord may have this, my lord, for the time. এরকম একটা থাকার কথা ঠিক my lord এর কাছে। এটা দিন।
No, there is no compilation. This compilation from the side of petitioner.
I'm obliged, my lord.
Yes. And you are asking for which this compilation?
Yes, my lord. Okay.
So which judgment you are referring?
I am referring to, I was referring on the second list of.
Second list, I'm not pressing.
Oh, second list they are not pressing, but I was harping on the second list initially. They are not pressing now, my lord. But
No, I have never praised
না
that.
না করেছো
Aare.
আরে
But
করেছো
your lordship says page 10 is your lordship judgment exactly on this point, my lord. Your lordship has considered everything and no, or not on
No, no,
limitation, my
in
lord.
this case, already proceeding initiated,
Right.
thereafter you have paid.
Right.
In those
Absolutely.
cases, they have paid.
No, 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 no,
They
no,
are-
no. Sorry, my lord, no. In all those cases, my lord, the issue is whether post-prosecution payment would entail quashment or not. My lord, Honorable Supreme Court said yes. Your lordship has said yes. This Honorable Court has said yes. All after FIR, my lord. But had it been paid before FIR, then there could not have been FIR at all. So all are post-prosecution. See page 10 once, my lord. Just kindly see your lordship's judgment, my lord.
No, I remember that judgment.
My lord,
I have,
Vishal Kochar, my lord.
I have,
Exactly on this point. But see factual matter.
I have already delivered many judgments.
Right,
I
your
think
lordship is
more
absolutely
than
right, my
10
lord.
judgment I have already delivered on those issue.
But if I may just place one paragraph, my lord, page 6, page 2, 2B. Sorry, page 10, my lord, para 2B. Vishal Kochar, my lord, is exactly on this point.
My judgment, you are
I'm
referring
obliged.
my judgment or
My lord,
compilation?
My compilation, my lord, page 10.
Vishal Kochar, yes, page
My lord, kindly see page 2, para
10.
2B. A complaint was lodged.
1 minute.
I'm sorry, page 10, 2B, small b.
Yes.
A complaint was lodged.
2A. Page number 10. You are asking for page number 10.
I'm obliged, my lord.
Yes, paragraph 2, 3.
Small b.
No, there is no.
Only at page 2, my lord, para. Oh, কি করেছো? আরে তো না তুমি না না আমরা তুমি দাও কেন 100% মানে কি এটা
That judgment I have referred in my judgment.
everything is referred to, madam. This page 10 once. But this is a consistent view, my lord. Of
my
the
lord,
report.
only thing is that
আরে আমি তো only thing আমি তো এই থিংটা এখন
হ্যাঁ তারপর
page 2 para 2B a complaint was lodged. Vishal Kochar, my lord, has gone.
Yes, yes.
I'm obliged. 2B, my lord, please. A complaint was lodged by the opposite party number such and such with the Deputy Commissioner of Police Enforcement Kolkata, kindly see 17/10/2013, which in turn filed by the officer in charge of such and such has deducted such and such, but has failed to deposit the same. And such fact came to the knowledge of the complainant in course of inspection. The petitioner was alleged to be persons of the company. Thus, a prayer was made alleging criminal breach of trust. Then your lordship will see 406, 409, 34. Then 2C. Subsequently, after completion of investigation, the investigating officer submitted report in final form. Then, my lord, 2D. It is the contents of the petitioner that on 17/10/2013, the complainant visited petitioner's company and carried out the inspection of such and such due to alleged default in the provident fund payment towards employees' contribution of the provident fund for the month of August amounting to such and such was deducted, pursuant to which a notice was given. Then on the very same day, 17/10/2013, without according any time, the petitioners to pay off the dues, the concerned provident fund authority written complaint filed. Then, my lord, will see it was paid. Then 2F on 28/10/2013, company complied with the notice given and paid 66,083. So it is all post prosecution, my lord. Then again, my lord, the 7A 2H your lordship has dealt with the 7A document, which in that case which I have just placed so far my case is concerned. Then para 3 in running page 13, my lord, your lordship has considered two Supreme Court judgment, one judgment of this honorable court. And then there is a detailed discussion, my lord. The law was succinctly laid down by your lordship, my lord, at page 14, my lord, paragraph 5. If I may just place para 5, my lord. Having considering the contention of the petitioner as well as the complainant, this court is of the view that it is the duty of the employer to deposit the PF within 15 days by month. But they come to know about the non-deposit of EPFO only after inspection by the complainant. Subsequently, they have been deposited the entire amount along with the interest as notice, and also it is admitted fact that the said amount was credited Accordingly, there is no dispute in the instant case regarding non-payment of the employee's share of provident fund contributions within time, but later company has deposited the entire amount along with the interest. Furthermore, it appears that the Honorable Supreme Court also quashed the proceeding of similar like the instant case. In this instant case also, the entire amount along with the interest having been paid as evidenced by the copy of the check dated such and such, there cannot be any justification for further continuation of the proceeding against the petitioner with the payment of the entire dues. Nothing remains outstanding. Further continuation of the present proceeding will be sheer wastage of time and money. In fact, Adani Cotton Mills Limited, the Commissioner of Police, the Honorable Supreme Court of India, paused the proceeding in view of the payment of dues being partly deposited and partly secured. Accordingly, such and such was quashed. Prior to that, my lord, I just show one more page, my lord, before I conclude. My lord, see page 8. This was the judgment of Justice Bosak in the similar line. Starting from, my lord, page 3, Justice Pranab Kumar Dev, as his lordship then was, Justice Bosak's judgment, Justice Sholendra Prasad Talukdar, as his lordship then was, page 6. All are on the point, my lord. My lord, these proceedings are, my lord, your lordship knows, my lord, that traffic challan cases, these are like traffic challan cases.
That's why I think in my judgment I have discussed about the committee.
Yeah, absolutely, my lord. And you, my lord, I was not aware of the judgment. Because that was not, published
I
at that
think
point.
in another judgment I have detailed discuss about the desire of the higher authority.
My
There are thousands of cases
which is
pending
pending like this.
when payment has already been made with interest.
Absolutely, my lord. That was
What purpose will
my lord.
punish to send them jail?
No, my lord. The only thing is that
ওইটা কমপ্লায়েন্স মাই লর্ডের অর্ডারটা কমপ্লাই করে কমিটি করেছো?
সেটাকে I'll have to take instructions to that effect.
I have not.
We have
that
not given,
direction.
we have
That
not
was
given that
direction
direction.
comes from the some higher authority.
That they don't do, my lord, that's the difficulty.
No, that instructions to till date I do not have. My lord.
Held here, that is only wastage of time of the court as well as money, exchequer of the government. What is the purpose when there is a compoundable, when there is a payment already made?
Interest, my lord, your lordship is
My lord,
interest.
My lord, only thing is that this Provident Fund Act was made for the benefit of state legislation welfare.
I know very well.
This is this is under
I know there is a punishment.
Absolutely, my lord. This was made why? Because the workers should not be kept in such a fashion that their payment should be sustained. In such
Second
circumstances,
time they default, you can proceed.
but in such circumstances also,
First time, if they came to know there was a fault from the side of company, and company realized and paid with interest,
that point of time the entire thing that can be a compromise.
Stop.
That should be stopped. But some way or the other, in some cases, it do also happens that there were several notices given. They also don't pay. Only after this kind of things.
That facts.
That is the fact out here.
Yes, that indicate that fact.
That is the fact, my lord.
Despite several notices, if
Absolutely,
they
my
fail to pay, then the question is different.
My lord, let's go through the FIR first. In fact, 34.
এই তো cyclostyle FIR দেখো
Every complaint cyclostyle, I find.
Absolutely.
Apply their mind, my lord.
No. It is not like that.
Maximum cases I find cyclostyle.
Dot filled up.
My lord, kindly comes to annexure P4.
Action দাঁড়াও আগে page 35 টা my lord কে my lord sees my lord the FIR is
No,
dot against dot
That
it is submitted dot and then my lord this is due. Is there any mention that the notice is not complied with? Nothing, my lord.
No, that is FIR. FIR is not the encyclopedia of facts, my lord. That has to be goes to the investigation.
What investigation?
Primary fact is that there has to go through.
Told in the FIR.
The primary fact is that
Don't argue with each other. I am here.
He has made a statement that FIR will divulge that there was a prior notices.
Yes, let him complete. You have already completed. Let him complete. Yes.
My lord, initially this FIR was lodged in the year 2017. Prior to that, there was another
complaint
notice
was lodged 2017.
2017. Yes. They asked for an anticipatory bail. After that, they got anticipatory bail and they have remitted the dues. That is the fact, actual fact. The only point of consideration is that at that point of time, that means it's a subsequent payment, not when initially when we are asked to pay that amount, they never paid to that effect. Initially in the petition itself, they have stated that there was a lockdown, there was a recession going on subsequently, and this due to which they tried to pay it also, but there was a lockdown in the company and subsequently it came down.
That must be considered from your side.
That has been considered.
You know the plights of the public at that situation.
That has been considered. After considering also, my lord, thereafter also, only after this.
Is there any due?
No.
Now. So
no. There is no due.
What steps taken from your side?
But my lord, if that
Take instruction in this case.
let me find out to that effect whether they have due, whether they have any.
Go through the judgments.
But I'll go
passed by this court. Several benches passed this judgment, and I have discussed many judgments. Supreme Court also held the similar view.
Other views were also taken by some of Supreme Court and this High Court also. My lord, I am giving this to your lordship.
Subsequently.
Subsequently.
1990 বলছো subsequently.
না,
My lord, এটা 20
No, others were also there. My lord, no, prior to
how
this,
can
not subsequently, prior to this.
1980.
No, thereafter there was a Supreme Court.
Judgment
Amar 1980. That not has been.
Any other submission do you have?
But I'll
apart from that.
Yes, my lord.
After getting antiseptic bill, they
Right.
paid with interest.
Yes, they have paid.
You are admitting.
That is not. We cannot challenge that. But that is paid.
You
That's
have
admitted.
accepted. You have already disbursed.
7 proceeding drop. I've given the document.
7 proceeding drop.
ওই তো আরে যেটা দিলাম এখন ওই যে পুরো টাকা
You take proper instruction in this case.
এই দেখো এটা
I'll come up. I'll come up on the next day.
Yes.
Secretary.
2017
For orders.
For orders.
No, first of all, you take the instruction.
I'll come.
Thereafter, I will order on that.
I'll come up. I want to read. 7 and 10.
Having heard the submission of the learned counsel. Cases are pending in
Well,
High Court also, in trial court also. What is the purpose?
I'll come up.
Your lordship will only come across my lord quashing petitions. No appeal or no my lord conviction. No revision from conviction. Because my lord, once money is paid, they don't do anything in trial court. Only the cases.
That's why I am asking. I have delivered more than 10 judgments.
I'm obliged, my lord.
Thereafter, they did not prefer any appeal.
No SLP, my lord. I've checked.
So they are satisfied.
So those are my lord, those have reached finality.
I'll come up to that effect, my lord.
Or I'm taking your lordship.
They have obliged, my lord.
My lord, I am appearing for OP number 2. I led by Mr. Shotodru Lahiri, sir. I am praying for a note today, my lord. He is not in this court today because of difficulty.
Petition of your lordship has heard me. There's a case of part payment.
420.
420-406. Well, it's a complaint case. Just these 2 paragraphs, my lord, your lordship had extensively heard me. Para 3 says, my lord, page 24. Complaint starts at, my lord, page 23.
Part payment has been made.
Admitted, my lord. It's not my case only. It's admitted by.
On this issue, I have delivered many judgments.
Many judgments, my lord, absolutely. But it says para 13 only once, my lord, page 27, para 13. The total amount payable.
27.
No. 27, page 27, para 13. That the total amount payable against this contract of ADMS was 85 crore 91 lakh 36,555. The total amount paid by such and such against the loan is to
2 crores
95
95.
lakh such and such from each own source, and 47 crore 58 lakh 90,181, an amount of 35 crore 36 lakhs 83,456 is due. Do I need to argue further before your lordship?
When he will be available?
Not any day, my lord. Any day, my lord, please. Or today 2 p.m. also, my lord.
Today already I have fixed many cases. On 28th,
28th, my lord.
you have already completed.
Your lordship may mark it as part hard, my lord.
The part had already it
Already
is
marked.
already marked.
Oh, bless.
Item number 32, Lordship, I'm here for the petitioner. The Lordship had heard me long time back, Lordship. The opposite party was replying, Lordship. They are not available today. I've spoken to Ms. Das. She is appearing for the opposite party. The Lordship will fix a date. She is to complete her reply, after which I will just respond to the 406-420, Lordship. Supply of goods, dispute regarding quality of goods. They've come up with a complaint. There have been continuous transaction over the years. Part of the good, Lordship, there was a dispute.
None appears on behalf of the opposite party. Of petitioner is requested to inform the learned counsel for the opposite party with regard to the next date of hearing.
Item 33 to 35.
33, Your Lordship, I'm for the opposite party. 33, 34, 35. 33, I'm for the petitioner, Your Lordship. Your Lordship, in this matter, the matter has been sent to mediation, and on the last occasion, we have not got anything from the mediation. The matter has not been went to mediation, though Your Lordship had
Report
sent
has been received.
Your Lordship, it will come to
Report
Your
এসছে?
Lord.
কবে দিয়েছে? No, no, এটা the earlier report. Thereafter, এটা এটা কমপ্লাই করতে বলেছিলাম, আপনি পাঠিয়ে নেন।
পাঠিয়েছিলাম
কোথায়?
Mr. Basu, Mr.
18/9 পর। Where is that? Where is that? Where is the report? Where is the compliance? তুমি পাঠিয়েছো যে? When you have sent this order to the registrar, where is noting? What is the stage of the mediation?
Your Lordship, mediation has not been started because we had not been informed. We had not been slotted any date or anything for the mediation. And it's for the same thing for the petitioner also. I had confirmed from their advocate.
Both are still ready for mediation?
Yes, Your Lordship, both are ready for the mediation. I believe Mr. Pulok Basu is appearing for the petitioner. He is
My lord, we are agreeable to it, my lord. Just that somehow perhaps the file got stuck in the process, so
Why
they have not sent us
started?
a notice. My lord, the mediation is perfectly on, my lord. Both the parties are agreeable to that,
Already the record has been sent to the mediation center.
my lord.
The order has been communicated long back. I am keeping at 2 p.m. You inform the secretary to come. No,
My
secretary.
lord, would make it time. In that case, my lord, kindly make it not today. We'll just try to have a word with the land secretary.
I will ask the secretary why compliance has not been made.
Very well, my lord.
Inform secretary, High Court Legal Service Committee. At 2 p.m. please come. First matter.
first matter.
First matter. Obliged, my lord.
Give him the number so that he can confirm. Number দিয়ে দেবে. Please give him number. You supply the number to the secretary. Ask him to come first. Next. Next matter. Secretary, Registrar, Secretary, High Court Legal Service Committee. Yes, next.
Six to 37. 36, my lord. Mr. Anirban Mitra is appearing on behalf of the opposite party number 2, my lord.
My lord, Mr. Arun Kumar Maiti is appearing for the opposite party 2 in 37.
My lord, I am appearing for the petitioner in both the matters. So far as item 37 is concerned, both are my lord, related matters, my lord. Your lordship has heard me in the past with regard to that auditor issue, where proceedings were initiated, my lord, by the registrar of companies against the auditor as well as, my lord, the directors of the company, but not the company itself. So what has happened, my lord, before another coordinate bench, this matter, my lord, I am representing the auditor, but the directors had also, my lord, challenged the proceedings through separate, my lord, proceedings before this court. So in one of those matters, my lord, item which pertains to item 37, and that this court, my lord, has quashed the case. This, my lord, pertains to item 37, which pertains to, my lord, complaint case number 43 of 2019.
This is a similar complaint.
Same complaint.
Same complaint.
Same complaint. So for all practical purposes, nothing is
No,
left.
this matter mentioned today in the morning in another case.
That is, my lord, pertaining to item 36.
No, one another matter
Yes,
was
item
there.
9. Item 9. From Mukherjee, I think, my lord.
Yes. So all these matter are same.
Similar. So far as item
Their complaint is same or not?
No, so far as 37 is concerned, item 37 is concerned, that, my lord, is the same matter of which I have handed over the judgment to you.
Okay. And 9 is also
9 is, my lord, a different company, but similar proceeding.
similar proceeding.
But 37 is identical to the judgment which I have handed over to your lordship, by which, my lord, the complaint case has been quashed. In the complaint case, my lord, I was an opposite party, and the other directors were also opposite parties, but the entire complaint case has been quashed by this honorable court.
And regarding 36?
36, my lord, it will be my respectful submission that a similar order should be passed.
Similar order
should be passed because the
My lord, I have to, I have to consider the
judgment passed by the coordinator.
my lord, I have to consider the judgment, my lord. I have to go through the judgment, my lord, for the first time. My lord, is referring, my lord, whether this judgment can be applicable in the peculiar facts of the case or the facts, my lord, relating to these revision applications are identical or not. We'll have to go over that, whether that can be used as a precedent or not.
my lord, I don't know which আপনি কোনটায় আছেন 36 না 37
37
No, so far as 37 is concerned, my lord, it has to be, my lord,
Yes,
it has become
that is his submission. We have to go through the judgment,
No, you are
whether
praying
this can
for
be used as a precedent or not.
similar order in 36 and 37.
No, my learned friend is
Let him go through the judgment.
Yes, then I will come
He's
back.
only appearing in 37. He's not appearing in 36.
No, 36, my lord, is 27.
36.
36, I understand he can consider the judgment and come back. But so far as 37 is concerned, the case is quashed. Nothing remains in this case.
Quashed. No, quashed in respect of only
Entirely.
entire.
Kindly see,
No,
my lord,
so far as
kindly see para 25 of the judgment I've handed over. The complaint and the proceeding being complaint case number 43 of 2019, pending before the learned second special court, Calcutta, West Bengal, under section 129 and 448 of the Companies Act is hereby quashed in respect of the petitioners.
so only in respect of the
Yes.
petition. That's
So,
why
now the reason why it has been quashed, my lord, is my
there are 5
That's right.
accused.
That's
One
right.
has filed one
That's right.
criminal
That's right.
application.
That's right. So very well. If my other friend wants to consider it and come back, I'll come back. No difficulty.
Hey, do you have copy?
Yeah, I have got just
You have received? Please supply the copy. Please supply the copy to him. এই 9 নম্বর কবে ফিক্সড করা আছে?
I think 21st November.
9 9 নম্বর 21 আগার So all these two matters we fixed
You
on
can come with that matter.
21st, 36 and 37. We fixed এটা করে দিন না। The copy of the said judgment has hand over to the learned counsel for the opposite parties in both the cases.
Detailed my lord, I pay for the petition. My lord has heard it extensively, my lord.
Who is appearing for the other side?
Well, Mr. Ghosh, Omurto Ghosh was appearing.
Sarjati
But
Datta.
complaint case, my lord, dispute with regard to sale of a flat. The matter had consumer protection.
Who is the
Consumer
other side?
I pay for the state. But complaint case, my lord, dispute is with regard to a flat. We had filed proceedings before the consumer forum. The matter traveled as way back to the Supreme Court, my lord.
I have already heard, you know.
Yes, my lord. Our submissions are complete. Only thing, my lord, if your lordship is keeping it on another date, I have an extension application pending. Lordship kindly extends my interim order, my lord. I have served it, my lord. CRAN 7 is pending, my lord. Will kindly service.
CRAN is out of time, lordship.
Yes,
My humble
it is out of time, my lord. I agree to that.
My humble submission.
What was the injunction order?
Initial.
Huh?
But the initial order was, my lord, April 29, 2024.
What was the order?
But stay of
the proceeding.
Lordship. Tala PS case number 20.
So after expiry of the interim order, what is the stage of the proceeding?
Lordship, on that point, instruction, lordship may fix us up a date, lordship. I shall come back with
You,
instructions.
you file the status report of the proceeding.
But kindly protect, because I was
But
enjoying.
how I can protect after?
But I filed a CRAN, my lord. A CRAN is pending.
You have filed, but what is the stage of the proceeding? Should I know?
Well, then keeps it next. Whenever your lordship is sitting, I will come back with the
Thereafter only I can take up the affidavit of service file on. You file a status report on that day.
Man, will come back to this.
Because we should know about the proceeding.
Yes, absolutely. Right, also, my lord, I pay for the petitioner arising out of a complaint case, my lord. Same, my lord, civil dispute arising out of an agreement to sale and a development agreement. Your lordship has heard me extensively. We have also filed a compilation, my lord. The OP number 2, my lord, was supposed to make submission. Mr. Chatterjee was appearing, my lord.
I am closing this case.
But my submissions, my lord, will then if your lordship, I can refresh your lordship's memory, my lord.
Because last occasion on the prayer of opposite party, case was adjourned as a last chance.
Yes, my lord, let me refresh your
Both
lordship's
sides
memory, my
must be present on the adjourned date. You are appearing for?
The state, your lordship.
The complaint
Mr.
case,
P.K. Proshun Datta is appearing, your lordship. I'm praying for a day's adjournment.
No, state is required. Maybe, but if there is a complaint case.
It's a complaint case, my lord. It's
So
like,
that's no
unlike the previous one, my lord, which was on 156.3, this is a complaint case, my
lord. No need.
Then no need for the state, your
Because it
lordship.
is not
Then
If
your
your
lordship
lordship wants, my lord, I can refresh your lordship's memory in 5 minutes, my lord. It's up to your lordship.
Yes.
My lord, kindly sees the complaint, my lord.
Yes.
It's in the certified copy. But first, before that, my lord, kindly takes up page 37, my lord, annexure P1, which is the development agreement. The owner of the land, my lord, Siddharth Setia, my lord, is the petitioner before your lordship. But development agreement entered.
Yes.
Under the development agreement, my lord, certain transactions had happened. Total of 4.01 crores had been paid to me. Out of that, my lord, 2.01 crores was refunded back by me as averred in the complaint for the reason that this developer had subsequently changed.
Bhagat?
No, I am Siddharth Setia, my lord.
Siddharth Setia.
What had happened, my lord? This OP number 2, my lord, company, your lordship sees two companies owned by him, my lord. Company A initially decided to develop the property, pursuant to which, my lord, 2.01 crores was paid to me. Subsequently, my lord, company B, belonging to the same person, was inducted as a developer, in which he also paid 2.01 crores to me. As I'll take your lordship to the complaint. The initial 2.01 crores which was paid to me has been refunded back by me. Your lordship will find that averment in the complaint. Part payment has been done. Apart from that, my lord, there is a civil suit which has been filed by him, which is pending before this High Court. I have annexed the plain matter on the self-same cause of action.
Plaint has already.
Yes, it's pending.
No, plaint has annexed.
Yes, I have annexed it. And my Order 7 Rule 11 is also pending for the simple reason, which is also will appear from the complaint, my lord. The transaction is of 2014. The complaint is of 2021. There is no one line reason also. The only reason which is there, my lord, is in 2020, he comes to know from someone that I am trying to create an encumbrance on the property. That is also his case in the civil suit, which is also, my lord, barred by limitation because I have filed an Order 7.
What is the main allegation?
Allegation is, my lord, this 2.01 crores he has paid, I have not refunded that. He says, what he is trying to demonstrate, my lord, if I can take your lordship to the complaint, my lord, this lordship kindly bears with 2 minutes. But the certified copy. But if I place the complaint, but may I please? But the complainant is a permanent resident of Kolkata and a businessman of repute. But this is the part of the certified copy, my lord.
Examination of the complainant is there. Yes.
Complainant is a permanent resident of Kolkata and a businessman of repute. The complainant is a director of various companies incorporated under the Companies Act, including my lord kindly notes these names: Harmony Vinimay Private Limited and partner of BKS Infra Projects LLP. But then I may skip to paragraph 3. The accused persons, sometimes in April 2014, my lord knows the date, represented to the complainant that they are the owners of a land measuring 113.3574 decimals, more or less situated, lying and comprised in various dags and recorded in various kotiyans at Moza Pathuri Ghata, jail number such and such, and they want to develop the said land, details of which has been given in Schedule A, and an MOU was signed on 29th April 2014. That is the document which I showed you lot at the beginning. The accused persons informed the complainant that they have marketable and sellable right title and interest over and above the said land, details of which has been mentioned in the MOU, and a deal would be made through their company, Intimate Promoters Private Limited. Malo, this Intimate Promoters is my company. On 21st May 2014, Harmony Vinimay Private Limited, which is one of the company of the accused, my lord, issued 2 checks for a sum of rupees 51 lakhs, being check number such and such, and rupees 50 lakhs, being check number such and such, respectively in favor of
He is not accused, he is a complainant.
No, but under the agreement, he had to give me a security deposit. These are terms of the MOU, my lord. I'll show you that.
The complainant is director of this Harmony Private Limited company.
Complainant is a director of the Harmony company.
Yes.
He had to issue me checks, my lord, because he had to pay me security deposit in terms of the MOU. That's one of the clauses of the
Yes.
So, my lord, 2 checks of 50 lakhs and 50 lakhs have been issued to me. My paragraph 6. On 16 September, the complainant through his company Harmony Vinimay further paid a sum of rupees 1 crores to the said Intimate Promoters, to which the accused number 2 and 3 are directors. But kindly seize paragraph 8 now. Therefore, it has been decided that the said land would be developed through the complainant's another company, BKS Infra Projects, and thus BKS Infra Projects from 7th April 2015 till 11th April 2015 paid
So we will
2.01
again
crores.
assemble at 2.
We come back at 2.
Lordship, if I may request, Lordship, I was supposed to appear in item number 19, opposite party number to the interim order has been extended in that matter. Lordship, I request my appearance may be
Why?
noted. Lordship, I was on my way only to I was rushing to the court.
It appeared. Why you are giving the slip?
Lordship, it's my humble request.
No. I have already recorded. I think you are not there. So how I can receive your name or
Lordship,
incorporate your name? This court finds no reason to interfere with the impugned judgment and order passed by the learned courts below. Consequently, CRR 4568 of 2023 stand dismissed. Connected application, if any, are also thus disposed of. Purport. Yes, purport.
2 p.m. matter, item number 6.
Session. I'm extremely sorry I could not come in the morning session. This is my application. The Lordship will find that this is a case of 498A.
Who is appearing for
After
opposite? Okay.
after 15 years of the marriage, my lord, but the couple was married, my lord, I think almost 15 years. But this affair was started against the present petitioner and the family members. But the marriage took place in the year 2012, and the instant case was started after 11 years, the 18th of March 2023. Initially, when we filed the application, your lordship will find we have taken a ground that in terms of Lalita Kumari, there has to be a preliminary inquiry. Your lordship knows better than us that Lalita Kumari's judgment. But in 498 cases where there is a matrimonial dispute, the preliminary inquiry should have been contracted. But I relied upon two judgment of our High Court, which says, my lord, in cases of 498A, but it will be better for the court to refer the matter to the concerned police station for conducting a preliminary inquiry. And after preliminary inquiry, if anything is found, then the FIR should be registered. But in this case, as soon as the complaint was received by the police, they have started the case of 498. But very recent judgment of the Honorable Supreme Court held that view.
1 minute. Why you have shown not in session? You have to pause. You do not know how to operate. You pause it. 354. 354 section is applicable here. 354.
No, here 498A, 406.
Okay.
Yes, but if your lordship see 498A, 406, 307, 34, these are the sections.
Okay.
But so far as the 307 part is concerned, your lordship knows.
Petitioner number 1 is husband.
Yes, and other in-laws.
And petitioner number 2?
Petition number 2 is, is the in-law. Just 1 minute, let me see who is petition number 2.
To both.
Petition number 2.
Brother-in-law.
Yes, father-in-law.
Father-in-law.
Yes, 3 is mother-in-law, 4 and 5. They are teachers, brother-in-law and his wife.
Okay. Yes.
But I am on the legal issue. First, the preliminary inquiry was not conducted by the police. That is the reason,
That is compulsory.
Milord,
Preliminary inquiry is compulsory.
not compulsory. But in cases of 498A, your lordship knows in Lalita.
Here 307 is that.
But no ingredients of 307. Kindly see what is the allegation of 307. Kindly see the allegation of 307 once, Milord.
Come to the complaint.
Yes.
Please wait. Please take your seat. You will get chance. I'll allow you. Yes.
But this is internal page number 3, last para.
No. Where is the main complaint? Where is the complaint?
Certified copy.
You have not annexed the.
Yes, I have annexed it. Last 4 pages.
Last 4.
The certified copy.
Yes.
I got it. It's a lengthy complaint, 4 pages complaint, Lord. Your lordship will find, Lord, both of them are well educated. I believe, Lord, the petition number 1, Lord, he works as a station master. And so far as the opposite party is concerned, my lord, she is a teacher. Teacher too.
Yes. Where is the operative portion of the allegation?
Operative portion, page 3, last paragraph.
Yes.
Your lordship will find most of the 498A cases, this kind of allegation is there. Where, my lord, they tried to kill him by pressing her neck. This is the ingredients of 307. Whether, my lord, it at all, my lord, comes under the 307 or not, that is a debatable issue. And that is the reason, my lord, my humble submission before your lordship is this: the preliminary inquiry should have been conducted. And on the same day, the incident which they are alleging, my lord, I also lodged a complaint.
No, you have assaulted somewhere. I have seen in the case diary.
No, now, my lord, your
That
lordship,
allegation is not made in the complaint. Some physical assault was there.
my lord, assault has to be proved. Mayor saying that I have been, my lord, I have been
তখন
assaulted.
আমার বোন কি ঠকাতে গেলে আমার শ্বশুর শাশুড়ি সকল মিলে আমাকে কিল চড় লাথি ঘুষি লোহা রড দিয়ে আমার শ্বশুর প্রাণ মেরে ফেলার উদ্দেশ্য আমার আঘাত করে
Yes. Page 32, my lord, kindly see
So
page
you are
32.
not indicating. I am asking about what is the allegation. You indicate the allegation.
That is the allegation. So far as 307 is concerned.
307.
Yes.
Not pointing out. You should have point at least the paragraph where, because we are unable to read very prominently Bengali language.
Now, my lord, kindly see the injury report along with it, which, my lord, she has given.
So there is a allegation of 307.
This cannot be 307. My lord, kindly see. My lord, injury is
No,
allegation
no,
of 307.
even if 307 is reduced to 326 or 324, so that is a cognizable offense.
My lord, now kindly see the view of our High Court. In two judgment, I shall place before your lordship. Kindly see.
I will come later on. First of all, you come to the complaint and thereafter materials. And what are the grounds for your question?
Kindly see, she has to substantiate her injury, my lord, what she has, my lord, suffered. Now, kindly see 32. Page 32 is the injury report. Whether it is at all, my lord, comes under 307 or not. Page 32. Nail scratch mark. My lord, got it?
Yes.
Then bruise.
Sanjay
Then
Haldar.
abrasion mark.
Sanjay Haldar. Yes. What injury over right wrist, left arm, left side, neck, face,
Nail scratch.
mark.
Nail scratch. Nail scratch. My lord,
You
kindly
come to 34.
Then, my lord, kindly turn to one abrasion. Then one abrasion. This is the kind of injury she suffered. On the contrary,
Who is Bina Mandal?
de facto complainant.
Oh.
And on the contrary, on the same day, what the petitioner suffered.
China Mandal? So there is a counter case.
No, yes, kindly see page 33. What injury I suffered on the same day. I was attacked by a broken glass. My lord, kindly see my injuries now. Page 33, my lord, got it?
Yes, yes, I have.
My lord, kindly see. Cut injury. My lord, got it?
Yes, yes, I have already.
Then who has caused, my lord, attempt to murder to whom? It's an internal family dispute. This is number one between husband and wife. Entire family has been roped into. And this has been deprecated time and again by the Honorable Supreme Court. Your Lordship knows better than us. Time and again.
But both sides have suffered injury.
That is the
So
reason.
on what ground I can quash this case?
Lord, the same situation arises, my Lord, recently in Allahabad High Court. What Allahabad High Court has done, your Lordship kindly consider this judgment, and subsequently this was upheld by the Supreme Court. I shall place by my
Despite injury.
Yes.
Despite injury.
Yes. By Malayasis Gabai.
Yes. Which is the relevant paragraph?
Page 26, kindly turn.
Yes.
Well, the Allahabad High Court has sent it to Family Welfare Committee, and 2 months the affair was kept in abeyance, and it was sent to the Family Welfare Committee. Well, got it. These are matrimonial dispute, and both are educated person in our case, and subsequently this judgment was challenged before Honorable Supreme Court. Well,
So why you have not offered to settle the dispute?
But we are.
This matter has already been pending since 2023.
Well, we are ready.
If they are not ready, then
No, kindly
the
see this.
court may proceed. Yes.
Now, my lord, kindly see the Supreme Court's order. My lord, got it. In
This
this
one.
case, kindly see how many cases was started by and between the parties, including, my lord, the attempt to murder, my lord, the grievous act, and other
In
sections
this
are
case,
also there.
only 498A.
No, and then subsequently, Lordship, see para 4. For A, the cases filed by the wife against the husband as his family members. My lord, got it.
Yes,
Kindly
there
see
are,
the sections.
there are several cases.
Yes. The main case, the FR case, which was started, state versus so and so criminal case under IPC under section 498A, 323, 500C, 4, 506,
Both
307.
sides have lost several cases, more than 10 cases. 10 cases lost by
In our
wife
case
side.
also we have lost
In
a
a
case.
husband side, 10 more than 10 cases lost. In such situation, the view of the Supreme Court is different, so that matter can be sought out
This
among them.
Here, what is the allegation? Well, kindly see the allegation once. There is no ingredients of 307. This is number 1. Number 2, kindly see the allegation. All are omnibus allegation. I am covered by the other judgment of the Honorable Supreme Court.
After 11 years of marriage,
After 11 years of marriage.
is there any issue from?
I think one issue, one minor son is there. And now they are saying.
Is there any civil suit is pending?
Yes.
Matrimonial suit.
125 is pending by and between them. My lord, can call both of them. My lord, this is the, my lord, now the Supreme Court is saying, my lord, this is the duty of a court. Either you send it to the, my lord, the committee, district committee, or the court itself can interfere and settle this dispute, these kind of matters. And in this case, what the public prosecutor is saying, my lord, in the meantime, since the matter was pending since 2022, my lord, they have proceeded with the investigation and charge sheet is ready. Now, my lord, in this case also, when I prayed for quashing before your lordship, if the subsequently charge sheet is being filed, the same can be assailed in the. They are saying the charge sheet is ready, but it could not be filed. Yes. So charge sheet is ready. That means charge sheet.
Let the charge sheet be filed and you go before the trial court and pray for discharge.
No, kindly see what
if
Supreme
there
Court
is no such ingredients
see what
collected during the
Kindly see what
investigation.
Supreme Court is saying now. Kindly see it at once.
In FIR, cognizable offense has been specifically narrated, and during investigation also some injury report collected.
That your lordship has to look into. Kindly see para 8 once. Will not kindly see it.
Yes, please read.
The High Court, however, disposed of the applicant application filed under section 482 on the ground that the petition has been filed prematurely and the case is still at the stage of investigation.
This
The
is
High-
this is the same case.
Yes. Now kindly see the observation. Same case. The High Court directed the investigation to proceed and further directed appellants to join investigation. Your Lordship also directed us to join investigation. The appellants thereafter preferred the present appeal by way of a special petition in this court. The present appeal, this court, on the prima facie view of the matter, protected the appellants from arrest and directed the investigation to continue. Accordingly, respondent number 1 carried out the investigation and filed a report under section 173 in the court of CMM so-and-so. Since the police has now submitted a charge sheet, the appellants have additionally filed an amendment application seeking incorporation of pair of crossing of the charge sheet in addition to the pair of quashing of the FIR. So this is permission. Now what is held by the court? Kindly turn to para 14. Got it? Para 14.
Wait 1 minute.
Got it, Millard?
Yes.
Conclusion. First, we like to deal with the submission of the learned senior counsel, respondent number 2, that once charge sheet is filed, petition for quashing of the FIR is untenable. We do not see any merits in this submission, keeping in the mind of the position of the court, Joseph Salvaraj versus so-and-so. This court, while deciding the question whether the High Court could entertain under section 482 of the for quashing of the FIR, when the charge sheet was filed by the police during pendency of the 482 application, observe. Thus, from the general conspects and the various sections under this appellant is being charged and to be prosecuted would show the same are not made out even the prima facie from the complainant's FIR. Even if the charge sheet has been filed, the learned single judge could have still examined whether the offences alleged have been committed by the appellant, whether prima facie made out to the complainant's charge
Now
sheet
it
document,
is settled that even after filing the quashing petition against the FIR, even filing charge sheet, that can be continued.
Yes.
That can
That
be.
can
It
continue.
is a
This is a
settled position now.
Yes.
Mm.
Now your Lordship,
In this case, there was an interim order not to take any coercive action against you.
this case, same as this case.
Now investigation completed. They are waiting for filing charge sheet with permission of this court.
Let it be
Now,
filed. My humble prayer is
now you go through the charge sheet. Thereafter you come before this court or you pray before the trial court.
keep this matter pending. That is the reason.
Until and unless charge sheet has been filed, how this court can proceed this matter? Only on the basis of FIR.
No, that kindly see what
You
is
have
saying.
challenged FIR. I cannot go beyond the FIR now. Until and unless charge sheet you incorporate it in this case. Either you incorporate in this case. I will allow them to file their charge sheet. You receive the charge sheet and you incorporate charge sheet either in this case or you file afresh.
I shall do it. I'll incorporate.
Otherwise, I cannot proceed this case on the basis of FIR. When they
let them liberty may be given to file charge
and
sheet.
I also cannot go to the charge sheet without incorporating. So far as I gone through the record CD, I find there are sufficient materials. I am giving you liberty to pray before the go before the trial court. You withdraw this and you file.
If I do so, then my interim protection will be below.
Why? I'll give you liberty to pray for discharge before the trial court
my
as well.
interim protection which your Lordship has
Already interim production has been gone. There is no interim production. Interim order has not been extended.
Now my humble submission before your Lordship is this. Let them file charge sheet with the liberty of the court and view of this judgment. Let me incorporate the charge sheet. I shall challenge the charge sheet before Lordship's court, which is exactly what the Supreme Court is saying.
That is your choice.
Yes. Your Lordship can.
But before that, you go before the trial court. If you have a better case, you can get a chance to discharge from your case.
The view of the Supreme Court is very clear. Your Lordship knows better than us. Even after filing of the charge sheet, your Lordship has the power to assess the material which was collected during the course of the investigation and take a view. But I am seizing your.
It will take some time to serve the copy of charge sheet. Again, it will take some time. Better you go before the trial court and pray for discharge. There is a provision.
That will also take time. Your Lordship knows one.
Whatever may be, but this case cannot be kept pending.
For the pendency of the case, your Lordship.
You go before the trial court and asks for your discharge prayer. Where is the bar? Is there any bar?
There is no bar. At the same time, where after filing of the charge sheet, your lordship in a 482 jurisdiction has the power to set aside the charge sheet or quash the charge sheet.
No, not at all. Without incorporating charge sheet, how can I look into it?
I'm telling you, let them file the charge sheet because it is their submission. The charge sheet is ready. It is not my submission. They are saying that investigation is over.
That copy should be served according to the provision.
Your lordship has
How they can serve?
Your lordship can, if they direct, your lordship can always exercise that jurisdiction. That your lordship has in 482.
So all parties should be appear before the trial court so that they can serve the copy. I am giving a direction. Yes. No, I have seen all these things. I have seen. I have seen the law is totally different here because without incorporating charge sheet, without submitting charge sheet, materials cannot be brought into the record. And until and unless materials gone through it, I cannot dispose of this case only on the basis of FIR. This is the situation here. Your CD भी CD भी revoke. CD, please take your CD. এটা বন্ধ করে দিন। ভুল হয়ে গেছে বুঝলেন এটা কিন্তু Next.
Also, one matter, item number 7.
Item number 7,
Reason, Millet. No, Millet, what had happened is on the previous occasion, there was an advocate on record. Millet, I've been instructed by my current advocate on record that there were advocates on record appointed. Subsequently, Millet, they have sought for an NOC from the erstwhile advocate on record, Millet. However, despite letters being given,
You are newly advocate or?
We want, Millet, the clients are also in court, Millet. They want to appoint a appoint my learned friends as the advocate on record, Millet. However, since no NOC is given, Millet, we cannot proceed in this case, Millet, because the NOC.
Now it is settled that there is no need of any NOC.
Millet, therefore, Millet, we only wanted to bring this fact to your lordship's court before.
This fact, your already from Mr. Mukherjee, that is senior counsel who was appearing just by on the same ground, Milord, change of advocate, this was continuously adjourned. At last, Milord, your lordship was kind enough to make such order vacated and we could investigate. The petitioners could be arrested. Further revealing of the fact there are other victims who have been victimized by.
Have you submitted the charge sheet?
After his arrest.
No, Milord.
No, I have given liberty to
Yes.
submit the charge sheet.
Information for certifying the 8 persons who have been victimized for such their banks. Only this one.
What had happened?
Only
7 years the stay was being there. So data which are available at bank are not available in local bank. They have sent to the Mumbai. So data are being retrieved. That is why, since they have delayed the investigation by taking a stay, that is why there is a stay. Otherwise, I will ready to file charge.
Now the stay has been vacated.
May I submit one thing, Milord? Milord, it's my Milord, it is my application.
Wait.
Milord, only
Wait, I have to know about the investigation.
Very well,
What is the progress of the investigation? One person has been arrested.
I was arrested, my lord.
They have got the bail.
Released, and after being arrested, we could be getting the 7 victim persons, their statements, their bank accounts has been, first part has been we have got from this, and the other part from Mumbai, we are awaiting. That's much only. QEDB report, it was already there. Now they have disputed their signatures, which is already.
They can dispute anything. They can dispute. But what is the stage of the proceeding? When you will file the charge sheet?
By the end of this month. By end of this month.
Millet.
So I'm keeping in the month of December.
Absolutely.
You file your charge sheet.
Great, good.
And you incorporate your charge sheet also here.
That is what we would do, Millet. And then, Millet, I would argue, Millet, because
now the question is different. Earlier there was only FIR you have challenged.
My lord, I will
now investigation is at the fag end. There is no stay. You have already been arrested.
Millet, I would
you got bail.
Millet, I would just interjecting your lordship. Millet, the only difficulty would be, Millet,
how many accused persons?
Two are there. Both have been granted bail yesterday.
So you go before the trial court.
No, Millet, I was
no. I am disposing this case.
Millet,
I am disposing this
Millet,
case.
I was only praying that kindly grants me time, Millet. Mr.
Today I am not disposing because no new advocates come in this case.
Millet, I'm being led by Mr.
Because there is no need to keep this case pending.
No, Millet,
you have already obtained bail.
Millet,
my
case is that no prima facie case is made out in the.
Whatever may be investigation already done.
Millet,
so prima facie case has been established against you now.
No, Millet. I'm saying that there is no prima facie case. Millet, this is my.
You can say at any point of time. There is no case, false case, concocted case, whatever maybe you can say.
Grants me time today, Millet. I'm being led by Mr. Chatterjee also, Millet. Since I overcome this.
Either you are representing the petitioner or newly advocate are representing.
I'm also representing. I'm an assistant.
Once you are saying.
Millet, I have the wakalatnama, Millet. I have the wakalatnama.
So you file the wakalatnama before the court. Now give your name.
Millet,
you have given the no objection.
No, Millet, that is the difficulty. Millet, the advocate on record is not giving. The erstwhile advocate is not giving.
There is no need.
So, Millet, we'll file
anyone
it.
Can appoint anyone.
Millet, I'll come next week. Millet, kindly makes it not this week. I'll come next week after filing the wakalatnama. Millet, one day, Millet will not.
Why it will take 1 week?
Then kindly fix it at any time. I'll come tomorrow if you're
Who is appointed?
day after.
Give the name.
Monday. Tomorrow means Monday.
Please give your name.
Item number 20 to 23. No, 22 to 23.
No, 21 and 23. Why 23?
There are two matters, case and counter case.
20 and 21.
But I am there in 22, I am the petitioner.
Yes.
And the opposite party.
This is 22 and 23. 2:30.
2:30 now.
You wait.
2 p.m.
Yes. Who is other side?
State is here. Private opposite party is not here.
You have served the copy?
But I have served this in my affidavit.
So you want interim order to be extended? In the first step, someone is there on behalf of the petitioner?
But I was there. Your Lordship.
On behalf of the opposite party?
Trade for time because they wanted to get the record.
So let the interim order be extended. Already expired or
Already expired, yeah. Thereafter.
within time or?
But I tell you, Lordship, what has
So
happened.
without hearing state, how can I?
Yes, but I am carrying a judgment of the Supreme Court in this regard. But an interim order of stay has to be vacated by a specific order. But there is no such order in this case. What has happened is, what has happened in this case is that the interim order was extended to a certain point of time. Thereafter, we kept appearing. We did not file an application. That is the difference. I am carrying the judgment with your Lordship.
So there was a direction to file an application for extension, modification, and something else. So without that, how court can extend automatically?
It is my fault in the sense that we had not filed an application.
So you accept your fault.
But I pleaded that due to my erstwhile advocate's conduct, but we did not file.
So without hearing other side, I cannot. And now the question is, what is the stage of the proceeding?
Yes, your charge sheet has been filed.
So you have to incorporate those facts.
That is incorporated in my application. Charge sheet is already filed.
Now, what is the stage of the proceeding after vacation of interim order?
Because there was an interim order of stay, I do not think whether the trial court below had proceeded.
You think I want the present status of the proceeding, then only I can extend the interim order. If
Direction
for filing,
report to be with the present state.
Your Lordship has directed for the case diary to be here. It has not come.
CD is here, your Lordship. They have.
why you are asking for time?
Your Lordship.
Thirty fixed matter item number 20 to 21. Twenty to 21.
Whether this is parted matter?
My lord, this is part of the matter Mr. S.N. Mukherjee was arguing, my lord. He was in the midway. Now, my lord, today he is not available. That is the difficulty. My lord, when is the date?
So this is the case for.
I was beseeching my lord, if your lordship kindly keeps this on 5th, and my lord, the interim order let it be till 5th, my lord, and we shall take a chance on that day.
No, this matter is with regarding the other matters. A similar matter are pending before the Supreme Court.
That's what they are saying.
Yes, that is the case.
My lord, I have my submission consequent to them showing.
But this type of proceeding already been stated by the coordinate bench.
Yes. Justice Thomba Dr. Pal has passed an order.
The submission that is
Have you gone through that judgment?
Yes.
That judgment?
Yes.
And the proceeding before the Supreme Court totally different. The Supreme Court once again remind these honorable high courts not to proceed when the matter is seized by the Supreme Court.
Yes.
So you please.
Which matters is what my learned friend was submitting before my court. And there is a difference. Matters that we have. These matters are not.
This matter, the question involved in this case is not seized by the Supreme Court.
Yes, the rate circular that is paid.
And this is also arises from the rate circular.
My lord, similar case, my lord. It has been demonstrated already before your lordship.
When Mr. Mukherjee will.
My lord, 28th, my learned friend has difficulty. So, my lord, the 5th or 12th, my 12, let it be 12.
Final question. My lord, then keeps it on 12. Another matter, my lord, is also clear mine.
No.
My lord, keeps it on 5th.
5th, my lord, let it be on 5th.
Okay. Both.
Both, my lord, in both the matters.
There are so many cranes are appearing like 14 and 15. What are those?
No, all are extension of it.
And has been disposed by your lord.
So why it is appearing in the list?
Last matter is pending. My lord, in both the matters, my lord.
Yes, 14 and 15.
Item number 39.
I was placing the complaint, madam.
So other side is there.
Your lordship said your lordship wants to finish it off today. They repeated adjournments have been taken also, my lord. But just two paragraphs in the complaint, my lord, I will show your lordship. If your lordship still wants me to continue, I will continue. I will recall, just to refresh your lordship's memory, my lord, two companies by the de facto complainant by the name of Harmony Vinimoy and BKS. But I was placing the complaint. May I place the complaint, my lord, from
Piyush Bhagat is the director of
my lord, Piyush Bhagat is the director of
Harmony Vinimoy Private
Harmony
Limited.
Vinimoy and BKS, both.
Both.
Director and partner.
One is partner.
One is director. One is LLP.
In
One
one
is
company, he is a partner. In another company, he is a director. So you are placing the paragraph.
But I'll start from paragraph 5. It will help your lordship.
5. Yes.
On may I place it, man?
Yes.
On 21st May 2014, Harmony Vinimoy Private Limited issued 2 checks for a sum of rupees 51 lakhs, such and such, and rupees 50 lakhs. Man, under the MOU, he was supposed to give me a security deposit of 4 crores. I'll show that clause also in the MOU.
So 1 crore he paid.
1 crore he paid. Subsequently, my lord, paragraph 6, my lord. On 16 September, the complainant through his company Harmony Vinimoy further paid a sum of rupees 1 crore. So, my lord, total
almost 2 crores. Okay.
But paragraph 7, man. Thus, the complainant through his company Harmony Vinimoy Private Limited has paid a rupees 2 crore 1 lakh to intimate promoters.
Here allegation is to the so-and-so to which accused number 2 and 3 are directors and accused number 1 is the conspirator.
Yes, but
who with
intimate
collusion
promoters,
with the corporation
that
deceive and cheated the complainant. How it can be?
But kindly see paragraph 8 now. Thereafter, it has been decided. So, 2 crore 1 lakh was given to me. No qualms about that. But kindly see paragraph 8.
No.
Thereafter, it has been
2
decided.
crore 1 lakh.
Paid to me.
Oh, yes.
Paid to me, my lord. Paragraph 7.
Yes.
Paragraph 8, my lord. Thereafter, it has been decided that the said land would be developed through the complainant's another company, BKS Infra Projects LLP, and thus the said BKS Infra Projects LLP from 7th April 2015 to 11th April paid 2.01 crores to intimate promoters. Further 2.01 crores was paid to me. But now
so total 4 crores 2 lakhs.
Yes. But now kindly seize the next paragraph, that your lordship will decide whether I should proceed further. Intimate promoters, that is my company, refunded through check the said sum of 2.01 crores to Harmony Vinimoy, which was initially paid.
So new agreement has been.
No, same agreement.
Same agreement. How
that is the fallacy, man. The MOU, if your lordship kindly sees the MOU, that is at page 37, man.
When you return 2 crores, 2 crores,
but where is
1 lakh to Harmony, there must be a separate agreement.
No, my lord, because it was only, if your lordship kindly takes page 37, the MOU was between Siddharth Setia, who is the petitioner, and Piyush Bhagat, who is the owner of those 2 companies. There was no separate agreement for that. It was a continuing transaction.
So that after cancellation you have refund.
But there is no cancellation, my lord.
So how it can be transferred to one company to another company without any subsequent agreement?
Yes, no, man. It was supposed to be developed initially by Harmony Vinimoy.
Harmony is a company.
Company, man.
Director is the director of that company. Now next you come to another company.
It's the same person's partnership.
But he is a partner, only a partner. So other partners will not incorporate a new agreement.
There's no fresh complaint. But if I have already refunded back, where is the question of deception coming? If out of 4.01 crores,
now you go through the complaint first.
Yes.
That's paragraph 9.
Paragraph 9. The Intimate Promoters Private Limited refunded through check the said sum of rupees 2.01 crores to Harmony Vinimoy Private Limited. Thus, the resultant effect is that the complainant through his company BKS Infra Projects LLP paid 2.01 crores to Intimate Promoters, and BKS Projects will develop the same land owned by the accused through their closely held company Intimate Promoters Private Limited. Next paragraph.
So, property was developed.
No. Property was not
developed. No, nothing has
nothing, my lord. The developer, my lord, he was supposed to execute a formal deed of registration. Nothing done. I have highlighted those, my lord, in my petition. What are the fallacies in the agreement? Purely civil.
So now only involving 2.1 lakhs rupees.
2.1 crores.
2 crore 1 lakh.
Yes. For that, my lord, he has already filed a civil suit. I have annexed the plain which is pending before this. And I have filed an order 7 in that suit because, my lord, it's completely bad. Your lordship sees these transactions are of 2014.
Now
The suit has been filed in 22.
now come to another paragraph.
Yes. Sometimes in March 2020, to develop the said land as per proposal of HITCO, a portion of the said land was exchanged between HITCO and Intimate Promoters Private Limited in order to develop the said land and to get proper access to the said land. Keeping the complainant and the said BKS Projects LLP in dark, the accused sold the entire land to third parties and has not refunded the said sum of rupees 2.1 crores taken from said BKS Infra Projects LLP, thereby misappropriating rupees 2.01 crores.
So here is the main allegation.
Where is the
Once you have entered an agreement with Mr. X,
my lord,
and subsequently, without cancellation, without refund of the money, you have sold the land to someone else. That is the cheating.
That is his allegation. My lord, where is the question of, where is the deception? Out of 4, my lord, kindly sees the.
No, how can you sell the property to someone else once you have given a development?
But it has not been sold. My lord, out of 4.01 crores which he has paid to me.
That is the allegation you have
I have
sold.
already refunded him. That is his own avowment.
No, accused
kindly
sold
see
the entire land to third parties.
That is his
This
allegation.
is the allegation.
My lord, that is his allegation. My lord, for that a civil suit is pending. There he has claimed 2.01 crores from me.
That is civil suit for recovery of money.
My lord.
But you have cheated.
But where is the question? I have already 2.01 crores, his own avowment in paragraph 9.
But he is also a partner of another company.
But it's the same ongoing transaction. There is no separate agreement.
No, next.
Yes. But under such circumstances, it is submitted that the accused persons have cheated and deceived the complainant dishonestly to deliver the said land and committed criminal conspiracy to commit an offence to cheat and deceive the complainant and his company BKS Infra Projects Limited. It is further stated that the accused persons in furtherance of common intention to cheat and deceive the complainant and his company committed cognizable offence by selling the land behind the back of the complainant and by not refunding the said sum of 2.01 crores along with interest. But even if you take what has fallen from your lordship, but if there would have been a separate agreement with BKS, but I would have understood. There is no avowment also in the complaint.
No, whether you have sold or not.
I have not sold.
You have not sold.
My lord, no. Because he has failed to, there is no termination also of the agreement. He has failed to develop the land as per the MOU. And what are the instance fallacies?
That is the civil matter. Civil court will decide. But here,
had there been a separate agreement with BKS, but I would have understood he has paid me 2.01 crores. I have not refunded it, and I have sold it back. His own company.
According to your contention, you have not sold your land to anybody else.
Even the agreement even the MOU is pending till date. But kindly appreciate, there is no avowment in the complaint to the effect that the separate agreement was entered into with BKS. I would have understood that. I would have been out of this court. It's an ongoing transaction. And the complainant is the person himself. It's not the LLP.
Okay, I heard you once.
But there are judgments. If your lordship wants me to show that civil in nature, if your lordship wants me, my lord, I can show those judgments because I have given a compilation, my lord, on the earlier occasion. And I've indicated the paragraph numbers. But just
once again, you intimate other side. Okay.
Your lordship so desires, my lord, I will.
Mm-hmm.
Six.
If you sold the land, how he
I
will
will give an
develop?
argument to that, my lord. I understand, my lord, what has fallen from your lordship, my lord.
Even if the memorandum of agreement is exist, what is the value of that agreement or memorandum of agreement?
But I get your lordship, my lord. I'll do that.
So you indicate if there is nothing, any pleading, you must incorporate your pleading in the
By a
supplementary pleading.
I'll get.
Specific stating that we have not sold the
Land.
any portion of the land.
Great.
Old matter.
Old matter, item number 67. Old matter.
What is the report? Office report. The office report কিছু? What is the office? Who is appearing for the petitioner? Why you have come here? Because this court asks for status. I think record is not tracing out. Office report, the file could not be traced out. Ask for some time to trace out the record. You do not know about the proceeding.
It has been ended in acquittal.
Yeah.
Ended in acquittal.
That's why I'm asking about you. Where is the order?
That order.
Where is the judgment? At least you should produce the order. I can dispose of this. You are submitting. You have been acquitted. After acquittal, you do not.
For that reason, on the last occasion, a report was also that we are also not having that order. We also need to.
Record is not tracing. Report has and it can be disposed of.
I'm applying for the petition.
68.
This is the matter where the person was acquitted without serving notice upon the complainant and the victim. The complainant filed a case against the accused person.
Which section?
The case was under section 386, 323, 341. Now, subsequently, charge sheet was submitted. No notice was served upon the complainant. The charge sheet has been submitted. Subsequently, the trial proceeded. Now, when the trial proceeded, they were supposed to serve the summons. No summons was served upon the complainant or the victim. The complainant was the employer. The person who was restrained and assaulted was his employer.
Have you annexed all the orders?
I have annexed the evidence, my lord, the orders.
No, orders.
On the last, my lord, the matter earlier came up before my lord Justice Ananya Bandyopadhyay, when his lordship was pleased to call for the lower court records.
Which order? By which order lower court record was called for?
My lord,
So after charge sheet, filing of charge sheet, no notice was served to the de facto complainant, and trial commenced.
I have a preliminary objection to the submissions on many.
Thereafter, my lord, I will only. My lord, can I have the lower court record once?
Yes.
ওটা ফাইল পাচ্ছে না এইটা না এটা সেশনস কোর্টের মনে হচ্ছে
Acquittal by the magistrate. An appeal against acquittal was filed by a person claiming to be the victim. Who was the proviso to section 372? That was dismissed on the
let us come to that later on. Let us come to the
So why you can go back? No, why you can go back?
Whether summons was served upon the victim or not.
No, you have already challenged the acquittal order.
My objection, my lord, to the submission on merit, because first the point of law is to be decided whether this person is a victim or not. My lord, the question before your lordship is.
No, that is already been decided by the appellate court.
That is what they have challenged. They are saying that no, I am the victim. My appeal should have been maintainable before the sessions court. That point has to be decided first. Then sessions, when my lord decides that whether the case should go to the sessions court.
No, his point is different. His point is different. De facto complainant is right to get information when the charge sheet has been filed.
My lord, kindly see what is in challenge before your lordship. Kindly see the petition. The challenge before your lordship is the dismissal of the appeal against
It's under section 482. But I filed this application under section 482.
But what is under challenge, my lord? The challenge is the order of.
You have already challenged the acquittal order before the appellate court, first appellate
that
court.
was not admitted because the learned judge was of the opinion that victim can be the person who has been assaulted. The victim here is the pro forma opposite party.
So what is the relations between the victim and you?
No, my lord, it is not only the injury, but also the
No,
loss.
who is the de facto complainant in this case?
My lord, pro forma opposite party is the part.
Why you are saying you are a victim?
I am a victim because
How?
Well, I suffered the
You
loss.
are not the de facto complainant.
I am the de facto complainant.
You are the de facto complainant.
I suffered the loss.
So you are the victim.
So, my lord, the de facto complainant, my lord, kindly sees the provisions under which the charges were. It was only on assault. The employee got assaulted, not the employer. The allegation was for extortion. My lord, the allegation is that.
So he is also one of the victim.
My lord, if so, my lord, I'll make submissions on that. If my lord were to hold that he is a victim, then my lord has to remand back this matter to the sessions court for hearing of the appeal over there. So submissions of merit cannot be made before your lordship. Whether they got the right to be heard or not, that has to be decided by the sessions court.
Let it be remanded back, my lord, to the
No, my lord, in that case
First of all, I have to decide whether you come within the definition of victim or not.
the sessions court has
The
said
section. No, no, no.
Typically, it was
Victim.
386.
Definition of
Charge sheet
victim.
was not submitted under that section. No notice was served upon me.
Poxo. Victim. 2D.
2W. My only prayer.
Yes.
Record not available.
60?
7, the earlier order.
Oh, earlier order already pass order.
Directed the registered judicial service to have the information from the court below.
Already received. I think earlier order I have passed.
Yes.
Already passed. I have passed.
But report has come that no file could be traced. We are also not getting any certified copy for non-traced.
The trial court seeks some time to trace out the record. I have already passed order. Wait.
High court will do it. We have not found the file.
No, if you can file the certified copy of judgment of acquittal,
We have tried.
you have tried. Let us see what reports comes. ERPC. You see, victim means a person who has suffered any loss or injury caused by reason of an act or omission. So, for which the accused has been charged. An expression victim include his or her guardian or legal heirs. So, the company is also suffered here extortion.
There is no extortion in the charge sheet. Charges were not framed under extortion. Only assault,
My knowledge.
criminal intimidation, and wrongful confinement.
My lord, kindly
So
see
if
the
I
summons sent
suffer
to
that.
summons. I have just. This one is the summon which was sent to the present petitioner. And next one,
After filing charge sheet.
at the time of evidence.
Hmm.
Just see the back side. My office is there, my house is there. I'm a resident of that place. And my lord, kindly see the next one, which is of my employer who was assaulted. Backside blank. Well, that page, backside is blank.
Yes, I have seen.
But whether it has been served at all, that is also not known. And my lord, the victim came in 2009. This is an incident of 2008.
Please show me the order of charge sheet.
My lord,
Acceptance
I
of
have
charge
the charge
sheet.
sheet, my lord, that is that page.
Acceptance of charge sheet. Have you taken that plea at the time of filing appeal? That you have not given
That has
opportunity.
been admitted by the that is reflecting in the order of the learned.
Where is that? এই সব অর্ডার গুলো কেন রাখা আছে এইসব?
My lord, if my lord comes to the certified copy, last paragraph, from the record I found that summons was not really served up on the victim.
1 minute, 1 minute.
Certified. Third last page.
Yes. Hmm. Yes.
From the record, the last paragraph. From the record, I find that the summons was not really served on the victim. He had no occasion to know about
No,
the
no,
case.
decisions with reason. Where decision with reason that has
It's a 3-page, 2-page
judgment.
order. That is that is the
No,
magistrate
judgment of the sessions court.
last green pages. Last green. Last 3 pages.
13th of June 2014.
Yes, yes. Which page you are reading?
13th of
Page number?
last paragraph.
Page number?
Page number, criminal appeal number 8 of 2012.
Page number.
The first page.
First page.
Last
Okay,
paragraph.
yes. From the record, yes, I find the summon was not really served upon the victim. No, no, that is regarding the deal. I am asking about charge sheet. When the charge sheet was submitted,
Charge sheet is at page 26.
Page 26 is the charge.
Whether you see the sections under it.
that's why the notice is required. If the some sections are omitted during the investigation, during the filing of charge sheet, he must be informed.
The state would be in the best position.
No, no, order sheet itself, it will.
My lord, there is an order 27th of June 2012, just prior to that. This is a continuation of 27th of June.
You have to incorporate all the orders.
I have incorporated all the orders. Well, may I find it for?
Yes, you find out where is the acceptance of charge sheet.
As of
Before accept.
Whether the person is a victim or not. Because if he is a victim, if your lordship were to hold that.
No, no, why he appeal, his appeal was filed on several grounds. Why that point should not be considered at this stage?
It was dismissed on the point that the appellant could not have filed the appeal under section 370.
From the prima facie, no summon was served upon him.
That is on merit.
One I have seen only report given by police. How police can give a report without any attesting signature by never?
I am not taking your lordship into the merits. The point is who can file the appeal. Maintainability of the petition before your lordship. Maintainability of the appeal is under check. I am challenging the maintainability. This person could not have filed the appeal under section 372 provision. He is not a victim because the only sections under which the charge sheet was filed was physical.
So case go to the place where charge sheet has been submitted.
For that, my lord, the
Only for that entire judgment will be set aside, and again retrial will be started.
Even if that is so, my lord, I bow down to what first of lordship. That order has to be passed by the appellate court for which the appeal is to be filed. If my lord were to hold now that yes, this person is the victim, the case goes back to the sessions court, the appellate court. Sessions court will take a call on the merits of the case. If my lord were to hold that no, this person is not a victim, then the actual victim, the person who was assaulted, has to come up before this honorable high court and file an appeal. Because only when this order on merit has to be passed in an appeal matter, it cannot be passed in a revision. This is a revision. In the criminal revision, the merits of the trial cannot be looked into.
So the trial court must have looked into the entire grounds. Simply, he is not a victim. Can dismiss the appeal.
Because under section 372 only a victim can maintain appeal. Otherwise, they should have come to the high court. If the complainant wanted, he could have.
How you have given acquittal? Because there was nobody on behalf of the de facto complainant to raise any objection. Number one, from the very initial stage, when the charge sheet was submitted, removing some sections, whoever may be the complainant right to know about the finality of the investigation.
And
That has not been done. It is admitted.
But against that, the
So entire proceeding is vitiated.
my lord, now, my lord, against that, the complainant could have filed an appeal.
Huh?
Where could he have filed an appeal under section 378(3) before this honorable High Court? He did not do that.
You are confusing. You are confusing this course.
It is order, my lord. While the 19 determines who can file the appeal, not just the court cannot come and file the appeal.
If you go through the initial FIR, the extortion from the company or whoever may be the employer, he is one of the victim because he suffered loss.
Yes, he is one of the victims. Yes.
At that point of time, he was a victim. He did not get any opportunity to raise before the trial court. Charge sheet was accepted in his absence. Now, how the appellate court decide he is victim or not?
In that case also, my lord, if there is any problem, my lord, generally if there is a activity, we go to the appellate court, my lord. We do not file.
They definitely gone.
They went to the appellate court. Now, my lord, if my lord were to hold that since this petitioner before your lordship, who is actually the victim, in that case also, where can he is supposed to file an appeal, my lord, before the sessions court? If my lord were to hold that this person is a victim, then the sessions court order gets set aside. Then the appeal goes back to the appellate court, my lord. So the argument that is being placed by the petitioner is for your lordship to pass an order on this. Whether that your lordship.
No, I cannot pass. I cannot pass.
Now, my lord, as far as the submission of charge sheet, my lord knows, my lord, with your lordship's vast experience, my lord knows that generally there is an intimation by the police to the de facto complaint. My lord, that perhaps.
No, have you seen the summon how it was served?
My lord, someone comes after the.
No. Have you seen what report has been given by the summoning officer? Simply non-present, I could not serve. So whether that is accepted as a service, how someone can be served as per CRPC? If nobody is there to whom someone should be served, even if door is closed, what is the procedure to serve the someone?
That is with regard to the service of someone.
So entire proceeding should be vitiated only on two grounds. Someone was not served. At the time of accepting charge sheet, no opportunity was given to the de facto complainant.
That, my lord, the stated in the position is
That order is there, my lord.
order sheet is stated.
It is 27/6/2008. The lower portion, my lord. Lower portion of the.
27/6/2008.
Cognizance taken.
No
Charge sheet file. Cognizance taken.
That the offense has been left out, 386 has been no opportunity.
So
173 to II given. Option of finding an NRSD also.
have you annexed your appeal? Copy of appeal?
No, my lord, that has not been annexed.
You annex
Memorandum of appeal is not. My record is here. এই ফাইলটা আছে মনে হচ্ছে দাদা আমাদের আমি পার করি ওইটা দেখে না ওইটা না ওটা ম্যাজিস্ট্রেট কোর্ট
You have taken that plea? Pleadings?
Paragraph 5.
Yes, that ground was taken. When that ground was taken, that must be considered by the appellate court.
There is no provision in the CRPC for the pre-exam that complaint otherwise there is no
No, no, has to be treated as a victim. Is not there.
What I say is there is no right at all. CRPC only the state has the right.
No, 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 no. De facto complainant or victim can
I am
file.
also the victim.
372.
Yes,
372. Yes.
So that is what the complaint is.
Yes. Anything else?
Passing order of touching upon the anti-corruption of the abject.
No, no, no. Definitely not. Why should I? Why should I? ঠিক আছে
My lord, before your lordship rises, my lord, I have an unprecedented indulgence I am praying for, my lord. My lord, my interim order, if my lord, my other side is there.
Today expiring.
My lord, it is expiring on 21st, but next week I am absolutely doubtful, my lord. I might not be coming. Only for
So ask your junior to,
my
no,
lord,
not
kindly
today, no.
deprive me of the,
No, 26
my
is,
lord,
is still
the
there.
file is there already, my lord. The other side is
26.
also there.
26 November, 21st I will be there.
My lord,
19 I will be
21st,
there.
your lordship will be there. My lord, in that event,
Yes,
kindly
yes.
fixes it on
You ask your junior.
Wednesday as extension of interim order.
No, on 21st I will
Let
extend.
it appear under the head extension of interim order on the Wednesday.
You mention.
My lord, on Wednesday
I
will
have
not be there.
I have already allowed many advocates when the interim order is going to expire on the same day, they can mention an extension.
My lord, but on 21st I will not be there, my lord.
Your junior will be there.
My lord, your lordship wants to deprive me of appearance. Then
Why?
My lord, I will not be there.
No.
I will not be. Perhaps I will not be able.
There is a interim order. How I can extend further?
My lord, I have served upon the state. They are
Maybe, but I cannot pass order today. How I can pass order today?
It is item number 44.
44 not called, not called as.
My lord, then let it appear under the head to be extension of interim order on Wednesday, my lord. Well, only that much is much indulgence.
Wednesday?
Yes, ma'am.
No, Wednesday is the,
I
you mention on that day. Wednesday is the read petitioners.
Yes, my lord, that is why. Under the head extension.
So where is the problem if you ask your junior to come on 21st and mention? Interim order till 21st. So ask your junior. Before that, how I can extend?
My lord,
if I take a matter can be taken today or tomorrow, then question of extension is.
My lord, I bow down to
if I adjourn the matter.
My lord, only I was praying for an indulgence. Let it appear on Wednesday under the head extension of interim order. Nothing more I am wanting. Only let the head change. Because the application is also there. Much grateful, Lord.
My lord, item number 70, my lord.
No.
42.